Honorable the Chief Justice, Gujarat High Court, Honorable Judges of Gujarat High Court, Honorable Retired Judges of Gujarat High Court, Learned Advocate General, Honorable Dignitaries, guests, participants and members of the bar, a very good morning and welcome back once again. After a thought-provoking session from yesterday, we look forward today to yet another equally engaging and interactive session. Discourage litigation. Persuade your neighbors to compromise whenever you can. These words of Abraham Lincoln resonate today more strongly than ever before. Arbitration and mediation stands as a testament to that wisdom. In an increasingly interconnected and complex world, disputes are inevitable, but prolonged battles need not be. Today's conference brings together minds committed to strengthening this system, to addressing emerging challenges in enforcement, transparency, technological transformation, and cross border disputes. As commerce evolves, so too must arbitration and mediation. The topic for today's session is making of an arbitral award, essential parameters, stakeholder roles, and enforceability. During this session, we will explore essential parameters for rendering an arbitral award which can withstand scrutiny under Section 34 jurisdiction. During yesterday's session, while discussing on the topic of institutional arbitration, Honorable Mr. Justice Sikri, as well as Mr. Janak Dwarkadas and Mr. Shyam Devan, impressed upon the importance of a well-written arbitral award. Today's session will be particularly informative for arbitrators and prospective arbitrators. We now invite on the stage the speakers for this session. Honorable Mr. Justice S.J. Wazifdar, former Chief Justice, Punjab and Haryana High Court, and Mr. Birendra Saraf, Senior Advocate.
It is our privilege to introduce Honorable Mr. Justice S.J. Wazifdar, a distinguished jurist and former Chief Justice of Punjab and Haryana High Court. Justice Wazifdar enjoyed a long and respected judicial career after being appointed a judge of the Bombay High Court in 2001, where he had earlier practiced civil, constitutional, company, and arbitration matters on both original and appellate side. He went on to serve as Chief Justice of the Punjab and Haryana High Court before retiring in 2018. During his tenure on the bench, Justice Wazifdar handled wide range of complex commercial and civil disputes and was regularly called upon to adjudicate matters pertaining to arbitration law. As a judge, Justice Wazifdar has penned numerous judgments on the subject of arbitration, promoting limited judicial intervention and the importance of procedural fairness in arbitration. Justice Wazifdar has time and again advocated for the need of human touch when working in the judicial system. His deep engagement with dispute resolution is reflected in his post-retirement work, including appointment as arbitrator in high-profile commercial arbitrations by the Honorable Supreme Court. Well regarded for his thorough judicial temperament and balanced approach, Justice Wazifdar continues to contribute to the development of alternate dispute resolution and commercial jurisprudence in India.
Mr. Birendra Saraf, Senior Advocate, built his name through sustained appearances across high-stake commercial disputes, writ matters, restructuring insolvency, and civil litigations, and was also university topper throughout his LLB, and later earned a PhD on judicial intervention in arbitrations in India, a theme that fits his reputation as a counsel on complex arbitration and public law questions. His early training was with the chambers of Honorable Mr. Justice D.Y. Chandrachud, former Chief Justice of India. Designated as a senior advocate with effect in 2020, Mr. Saraf was later appointed as an Advocate General of Maharashtra. Mr. Saraf has over the years appeared in a plethora of cases of public importance involving complex questions of law. He has also acted as an arbitrator, mediator, and conciliator. We look forward to your insights on the subject, sir.
We now invite Honorable Mr. Justice Wazifdar to either come to the dais or Lordship would want to.
The Honorable Chief Justice, Mrs. Sunita Agarwal, the Honorable Judges of this court, former judges of this court, Advocate General, and members of the bar. Mr. Saraf will be leading this session. I just wanted to make a couple of introductory remarks. Can you please allow me 1 minute of nostalgia? My first out-of-town brief was in the Gujarat High Court, where I was being led by Mr. Bharat Shelat. It was a case under the Foreign Awards Recognition and Enforcement Act 1961. Over 45 years later, the same subject, arbitration, brings me back to this great High Court. I can thank the Chief Justice, the Honorable Judges, and members of the bar for giving me this opportunity. When I told another legend of the Bombay High Court that I got my first out-of-town brief, he said, "Where is it?" So I said, "In the Gujarat High Court." He said, "Well, the first thing you should do is try and find out where that great Advocate General of Gujarat, Mr. Thakur, is appearing and go and see him." He is not a legend today. He was a legend way back then and even before that. And so the first thing I did was, the moment my case was over, was to ask Mr. Shelat, and he took me to see the Advocate General. Now, the reason I said Mr. Saraf will be going in first is this, and this makes me sound almost like a stuck record. Ever since I became a judge, I spent 2 minutes making it clear that I have chosen not to express any opinion on questions of law in public or other than through my judgments. It's just a personal choice. I don't say that the other way is wrong. I have made that decision. Of course, today things have become really sensitive. People pick up statements and then allege bias. But one of the reasons I don't do it is also because I won't mention the case. It's only a story I was told, but I believe it's true. A judge addressed the bar at a big function like this for about 40 minutes. People like Mr. Biren Saraf, all the smart youngsters at that time, picked up one sentence in those 40 minutes, reported it to the team, to his senior, and an entire strategy was built around it. What I'm trying to say is that's one of the reasons why I don't express my views in public. Nothing wrong in what happened. It was a perfectly valid approach. In fact, a smart youngster who picked up that sentence and made it. So today's topic, Mr. Saraf will deal more with the legal aspect. He's a more erudite person anyway. And I have some very strong views on the practical aspect relating to the making of awards. On two things, I will be addressing you on, I know I don't want to sound presumptuous, but on the reasons for an award being a sustainable award and what we can do to make them sustainable. With that, Mr. Saraf will lead the session. Thank you.
Honorable Chief Justice, learned judges of this court, former judges of this court, respected members of the bar, and ladies and gentlemen, good morning to all of you. Justice Wazifdar in his usual self said, "I'll lead the session." That's not correct. It's only on his direction I am commencing the session. to cover certain points. The whole purpose of an arbitration is that parties decide to have an adjudicator of their choice, at times to get out of the waiting in court, at times because they feel that the arbitrator, having certain specialized knowledge, would be in a better position to adjudicate that dispute. And it is great disservice to those parties when, after going through the entire exercise, at times for months, at times for years, when an award is challenged in court, it is set aside on some technical errors, on some procedural errors. The result of which is that years and months of effort have gone waste. Parties at times have to recommence the entire arbitration, and at times they lose both the energy, enthusiasm, or at times even the means to pursue the arbitration. And therefore, in order that arbitration is an effective means of dispute resolution, it is important that it culminates into a legal and valid award which can be sustained in the eyes of law before a court in which it is challenged. And these kind of errors in the award, the manner of writing of the award, technical errors, the procedural errors, are committed not just by people who have no judicial background. At times, and I'm sorry to say that, but awards which have been written by judicial office persons with a great deal of training, at times having held high offices, also fall and fail to follow the requirements of law while passing the award. I must share a couple of illustrations with you, which each one of which were passed by former judges of constitutional courts, where a matter came before the court and it was found it was a matter where a film actress had resigned from a contract to act in a play in a theater, saying she gets migraine, and she had terminated the contract. The producer had sued her for damages, and extensive evidence was laid, and both parties had brought in enough material on record. But after the matter was closed, the learned arbitrator decided to do some research himself on the internet about the effect of migraine and incorporated all that research which he did in his award. When the matter came up before the High Court, I convinced Justice Wazifdar, who was sitting single judge at that time, that even if you leave aside this material, there is sufficient material to uphold the award. I could convince him to uphold the award. But when it went before the division bench, with a great deal of sarcasm, said, "It's good somebody does research after retirement at least," and set aside the award. So this was an instance where material was relied upon by the arbitrator without putting it to the parties. There was another case where a former Supreme Court judge was an arbitrator, and the cross-examination of a witness was going on. And in the midst of the cross-examination, the learned arbitrator said, "Well, I followed the matter. I don't think anything further is required." Next day, he called the stenographer and dictated the award. Believe me, the award was a perfect award. Anyone would have come to the same decision, but the award was set aside because it failed in a fair procedure of allowing the party to complete his cross-examination. Now, there could be instances after instances which I can narrate to you all like this, where the award reads perfectly correct. Any person, a fair person, reading the award would say, this can be the only result and this is a right decision. But because the manner in which the award was written or the manner in which the procedure was followed leading to the award was set aside. And what was the result? The entire effort, the entire exercise was an exercise in futility. And therefore, it is very important that an arbitrator writes an award in a manner which can be sustained in court. And when I say sustained in court, there are always some issues about the view taken by the arbitrator. The section 34 now curtails a great deal of inquiry or going into that. The large part of the grounds under section 34 are more of procedural grounds. So, according to me, what will be a proper award? And I feel that an award which crystallizes the points of differences between the parties, decides the points for determination, and decides after giving both parties a fair opportunity, after considering the pleadings and evidence on record, after applying the applicable law, and following the statutory requirements of an award under the Act. If an arbitrator were to do that, largely an award would be procedurally correct. So, what are these? As I said, decide the points for determination after considering the pleading and evidence on record, after applying the applicable law, after giving both parties a fair opportunity, and complying with the statutory requirements of an award under the Act. And therefore, the following of a fair procedure leading to the award is very important, because a great many awards get set aside on a grievance being raised before the court that the procedure followed by the arbitrator was not correct, was not fair, deprived one of the parties of an opportunity of presenting their case. And therefore, it is extremely important that the procedure followed by the arbitrator is correct. Now, under the Act, parties are entitled to follow and frame their own, between themselves, agree to a procedure of arbitration. In ad hoc arbitrations, that is rarely done by the parties. I've come across very few arbitration agreements between two parties which set out a procedure of arbitration. So far as institutional arbitrations are concerned, to some extent, that is streamlined because the procedure is governed by the rules of procedure of the institution. But in ad hoc arbitrations, it is very important that the arbitrator, if parties are not agreed to a procedure, frames the procedure. And it is better that this procedure is laid down right in the beginning. And if the arbitrator lays down the procedure right in the beginning and invariably requests the parties to consent to that, most often than not, the parties will consent to it upfront. So it is better that the arbitrator frames a procedure of the arbitration right in the beginning and thereafter gets the parties to consent to that procedure. If they don't, then of course it is the discretion of the arbitrator. Now, what about the following of the rules of the Civil Procedure Code and Evidence Act? It is correct that the Arbitration Act says that the arbitrator is not bound by the CPC or the rules of evidence set out in the Evidence Act. Does that mean that the arbitrator does not have to follow any of the principles which are incorporated in the CPC or the Evidence Act? The judgments clearly say that though the Act may not strictly apply, but the basic principles underlying those laws, which involve a rule of fairness or certain important basic principles of law, those cannot be ignored by the arbitrator. Now, can an arbitrator say that since the Evidence Act does not apply to me, I am going to give an award only on the basis of hearsay? Now, that may not be legally permissible because that is a basic principle of law that hearsay evidence cannot be treated as any evidence at all. Or are Section 91 and 92 of the Evidence Act, can they completely be ignored? Can the arbitrator take into account oral testimony if a written document exists as regards the contents of that document without the document being produced? So that also is not possible. Can a disputed document, without it being proved by the party presenting it, can that be relied upon by the arbitrator? That cannot be done. So very often it is found that the arbitrators have misread the provision which says that the CPC or the Evidence Act does not apply to arbitration, as believing that none of the principles of those laws are applicable to the arbitrator. And that leads very often to the arbitrators thinking that they can act as they want to arrive at a decision. But the arbitrator surely cannot ignore the basic principles which are underlying these laws. And therefore, it is very important for an arbitrator to frame a procedure and also follow certain basic principles, particularly the principles of fairness, which are incorporated in the CPC and the Evidence Act. Now, the arbitrator has framed points for determination. Now, while framing the points for determination itself, it is important to consider the pleadings between the parties. At times, during submissions, issues are raised or claims are raised which find no basis in the pleadings. And therefore, it is very important that when the arbitrator is writing the award, the arbitrator carefully scrutinizes the pleadings to find that is any of the claim which is being asserted by the party, does it have a foundation in the pleading or not? Or is it actually been claimed in the pleadings or not? Very often it is found that the award grants something which is much beyond what is pleaded in the award, which immediately makes it vulnerable. So therefore, it is very important that this aspect is borne in mind by the arbitrator. Similarly, jurisdictional issues need to be decided upfront by the arbitrator. The arbitrator needs to consider as to whether the dispute is covered by the arbitration agreement. One part is whether it at all falls within the ambit of the arbitration agreement itself. Secondly, what is the scope of reference made to the arbitrator? It is possible that the agreement is very wide, but the reference made to the arbitrator is on a very narrow issue. Therefore, that reference also circumscribes the jurisdiction of the arbitrator, and that is important for the arbitrator to bear in mind. And more importantly than either of these two issues is whether the dispute at all is arbitrable or not. Because I will take you all through 34 and show that each of these are a ground for challenge to the arbitration award. And therefore, it is important that the arbitrator applies his mind to each of these aspects regarding his own jurisdiction, because the arbitrator ultimately is a creature of an agreement between the parties, and his jurisdiction is determined by the reference made to him, and his powers are circumscribed only in certain categories of disputes. In certain categories of dispute, the arbitrator has no power to decide those disputes. So if an application is made for enforcement of a mortgage before an arbitrator, then even if the other side possibly has not raised an issue of jurisdiction, the arbitrator needs to be conscious that this is a nature of dispute which I possibly cannot adjudicate upon, because this is a dispute which is not arbitrable. Suppose a certain claim is made which falls within the jurisdiction of a special tribunal to the exclusion of a civil court. Now that again is an issue which the arbitrator needs to be conscious about, because otherwise, and I'm not saying that the arbitrator should put it to the parties and ask both parties to address. And therefore, it's important that it is not as though the arbitrator cannot apply his own mind's on certain issues. At times, arbitrator does not get proper assistance. I found arbitrators taking the request of his own law clerks or interns, getting some research done on the point because the arbitrator is not getting proper assistance from both parties. The answer to that is it is better for the arbitrator then to put that before both the parties, say, this is what I feel is relevant to this matter. Please address me on this. And once that is done, then neither party can have a grievance. The difficulty arises when the arbitrator, without putting it to either party, incorporates such things in his award. That makes it vulnerable because the parties then go and tell the court that we never got an opportunity to answer this. So this is something which the arbitrator needs to be very careful about. Secondly, the reasons. You'll often find awards which will say, learned counsel for the claimant submitted this, learned counsel for the respondent submitted this. In light of the aforesaid, I pass the following award. Now, where are the reasons in that? Or the arbitrator at times says, I'm in agreement with the submission made by the claimant. But where is the application of mind by the arbitrator to the controversy at hand, to the pleadings, to the evidence on record, and then reflecting his thought process in the award, which has led him to a conclusion which is in favor of one or the other party. And therefore, reasons, as they say, are the soul of an arbitral award. They need not be elaborate, as the Supreme Court says. They need not be like a judgment. They need not be too extensive, but they should be intelligible. And they should reflect the thought process of the arbitrator, which has led him to one conclusion or the other. And in the absence of such a thought process, the entire award becomes vulnerable for lacking reasons. And the Supreme Court has time and again said that we are not going to analyze the adequacy of reasons. So long as there are clear reasons which are intelligible and which reflect that what has weighed on the mind of the arbitrator for him to have reached that conclusion, then the grievance cannot be that the reasons should have been more elaborate, more detailed. Now, one of the important things which an arbitrator needs to do is to show and reflect in his award that the arbitrator has considered the relevant material and evidence on record. Because otherwise, very often, an award is susceptible to challenge on the ground that the arbitrator has ignored the most material evidence. Though the Arbitration Act itself says now that reappreciation of evidence is not permissible in a Section 34 petition, but this completely ignoring a very material piece of evidence the Supreme Court has held is perversity or patent illegality, which may render an award vulnerable. And I must tell you all one thing, which I have always said, and the learned judges may also pardon me, that very often a learned judge hearing a Section 34 first decides whether he wants to set aside the award or not, and then finds a way to fit it into one of the grounds. So if the learned judge wants to set aside a ground award, giving it a label of patent illegality or perversity can be found somewhere or the other. But this reason, which is very often used by the learned courts, can be curtailed, or an opportunity to the party to raise such a contention can be curtailed. Because if the reasons were to set out a thought process which shows a consideration of the relevant material on record, then that will be easy. And this can be easily achieved if the arbitrators stop taking submissions from the parties in a pen drive and cutting and pasting those submissions into their award. Take a pen drive, give me your submissions, learned the claimants submitted the following, cut paste their written submission. the respondent submitted the following, cut paste their submissions. That is where the fault lies. And that's where you often miss out the consideration of the important contentions of both the parties. So, therefore, reasons are a very important aspect. I will close soon because I was told that we will keep our openings crisp so that there can be more interaction and question answers. So, I'll just close in 5 to 7 minutes. Important aspect of the, so therefore, the section 31 of the Arbitration Act has certain statutory requirements which should be there in the award. It says that the award should be in writing, it should be signed, it should state reasons, it should have the date and place of pronouncement of the award, and it should be delivered to the parties. Each of these sound so innocuous and obvious. Of course, it must be signed. Of course, it should have the name, a date. Of course, it should be delivered. But you all will be surprised that our law books today are full of decisions on controversies raised by lawyers on each of these issues, on signature, on date, on place, on delivery. Each of these have been subject matter of detailed judgments, and each of these points have been considered threadbare. Now, signature in a panel of 3 arbitrators, the Act says that if 2 of them sign, it is sufficient, provided the reasons why the 3rd arbitrator is not signed is set out in the award. And the reason for that is clear, that there should be participation by the 3rd arbitrator in the deliberation. Thereafter, if he has refused to sign it, it's a different situation. Now, the provision doesn't give a right to 2 of the arbitrators to say, we are majority. Now, whether he comes, he doesn't come, don't bother about him. We too can decide the arbitration. Each of those awards have been set aside by the courts, saying the award must reflect somewhere that the 3rd arbitrator was consulted, he was involved in the discussion and deliberation. And thereafter, if somewhere he refused to sign, then the reasons why the signature is missing of the 3rd arbitrator should be there in the, or the dissenting arbitrator should be found in the award. Though the courts have time and again said it need not be expressly stated, it could be possible that the it can be gathered from the circumstances. So each of these aspects, signatures, date and place, I think in the interactive session we will cover these in more detail. Then the interest part. The 1996 Act clearly gives the arbitrator the power to award interest right from the date the cause of action arose. So in the earlier Act, there was a certain ambiguity about the power of the arbitrator to award interest during the pendency of the arbitration, etc. But under section 31(7) of the Act now, it is clear that the arbitrator has a power to award interest right from the date of cause of action. And that is a distinction between a power of a civil court and a power of an arbitrator. Because in a claim for damages, the Supreme Court held that the damages, the interest can be granted only from the date of the decree, because that is when the claim crystallizes. But in case of arbitration, it can be given right from the date of the cause of action, that is the date on which the breach arose, because the Act expressly permits the arbitrator to award interest from the date of the cause of action. Now, the extent of award, it has been said that unless there is an agreement between the parties, in interest, it is very important that the arbitrator keeps a notice of whether there is any agreement between the parties on interest. If the agreement says that no interest will be payable on a certain claim, arbitrator then is denuded of his power of granting any interest. Or if the agreement crystallizes the rate of interest, and says that any claim will bear interest of 10%, then the arbitrator has no power to vary that agreed rate of interest. So, therefore, the agreement between the parties is binding on the arbitrator, and the arbitrator needs to follow that. In the absence of that, the arbitrator needs to be reasonable in the award of interest, because interest is only compensatory to compensate the party of being deprived of the use of money. And therefore, the rate of interest cannot be exorbitant, the rate of interest cannot be unconscionable, and that is the purport of the provision. There are two other aspects. Sir, can I take 5 minutes and close? There are two other aspects. One is of the regime of costs. Now, the new act comes out with detailed provisions as to the award of costs. And it also sets out what are the factors which are to be taken into account while an arbitrator awards costs. And those provisions really are very illustrative, because today, suppose a person makes a claim of 100 crores of rupees and finally succeeds only in getting 2 crores of rupees. Is he entitled to recover the entire cost of his arbitration? On the contrary, it is possible that in a given situation like this, the losing party should be awarded some cost, because he has been defending a completely frivolous claim, and therefore the Arbitration Act now permits the arbitrator to consider whether a frivolous claim has been made, whether a reasonable claim for settlement was declined by the other party, whether the party unnecessarily delayed the arbitration. And each of these aspects can need to be borne in mind. And actually, the award of costs in a commercial arbitration is really necessary today, according to me, because it kind of discourages people from raising frivolous claim, from dragging arbitrations, and from being an impediment to a earlier adjudication of an arbitration dispute. And therefore, the power of costs, award of costs, should be exercised by the arbitrators in a fair and reasonable manner. Then there is an aspect of what will be an interim award and what will be a final award. I think Justice Wazir will be touching upon that part of it. And lastly, I must say that the 2024 proposed bill proposed an amendment to an arbitration act. And that proposed that in every award, the arbitrators should state certain things. And on going through it, I find that that's in the nature of a checklist for an arbitrators. And if the arbitrators were to, after applying their mind, certify these things, then most of the grounds of challenge can be eliminated. And those certification, as it contemplated in the 2024 bill, which is yet to be passed, says that the arbitrator should state in the award that the parties before him were not suffering from any incapacity, that the arbitration agreement is valid under the applicable law, that parties were given notice of the arbitration or the arbitration proceedings and were able to present their case. So if you see arbitration agreement valid under the applicable law will be a jurisdictional issue. If the arbitrator were to apply his mind and give this certificate, that will be a conscious application of mind by the arbitrator. Parties were given notice, natural justice, fairness. The composition of the tribunal is as per the agreement. Once again, a jurisdictional issue. Procedure followed was as per the agreement between the parties. Procedural fairness. Subject matter is capable of settlement by arbitration. The arbitrability of the dispute. An award deals with only disputes falling within the terms of reference. Once again, the issue that the award has not exceeded the reference. So these are the facts these are the aspects which the 2024 bill said every arbitrator should state in the award. And if the arbitrator were to apply his mind on each of these aspects, and if we were to see the mirror in 34, most of the grounds of challenge can be eliminated if these questions are answered properly by the arbitrator. So, on that note, I will leave it to Justice Varita to carry it further. And I'm looking forward to the interactive session so that we were told it will be better if we have a longer interactive session. So, thank you very much. And I'm looking forward to the interactive session.
So let me start from where Dr. Saraf left us. Now, what I intend doing is starting a discussion as I see this as an opportunity for an interaction between the bar, the bench, and the body of arbitrators, and of course the stakeholders if that's possible, to share our experiences which would assist in making awards that are upheld. You can open the textbooks and see a lot of things theoretically, but to get over the challenges to an award, there are certain practical aspects which can be adopted. And that is what I think we as a body of stakeholders need to consider now. And something which you are not going to find in textbooks. Now, both an erroneous judgment and an erroneous award have adverse consequences. Why then is there so much emphasis and anxiety about erroneous awards? The answer is obvious, but sometimes it is necessary to underscore the obvious. The answer to this question is, in fact, the backdrop of the steps suggested and to be suggested for making awards in such a way that the possibility of a challenge, even if not ruled out, is at least minimized. Now, there is a fundamental difference between judgments and awards. And that is an important aspect. And I must tell you straight away that, to my mind, the realization that bringing it to the conscious from the subconscious, the effect of this is far more important. And sorry, at least is as important as the steps which we are going to suggest. There are two vital differences between a judgment and an award. First is that the scope of challenging an award is limited. And the second is that the consequences of an award being set aside are disastrous. When an award is set aside, the entire work goes down the drain to the extent of at least 75 to 80%. Because your option then is to go in for a fresh arbitration or to file a suit. Dr. Saraf has explained clearly as to how an award, even if it reaches the correct conclusion, is susceptible to being set aside if it is made in the wrong way. Now, look at the difference between the judgment and an award. An erroneous judgment can be rectified in several satisfactory ways. A first appeal, where all questions of law and of fact can be gone into. Even in the second appeal, judges with experience know how facts can be dealt with. In certain circumstances, there is always a window to deal with facts as well in the second appeal. There's a power of review, there is a power of revision. But two other powers are crucial. The power to remand and the power to uphold the judgment, albeit on different grounds and for different reasons altogether. That is not possible when it comes to awards. The theory which makes this difficult for a judge hearing a challenge is that ultimately, if two views are possible, the judge must cede to the arbitrator's view. So he would say that, look, if the other points had been gone into by the arbitrator, he may have held in a particular way. He may not have held the way I am, and two views are possible. Therefore, I cannot put my own reasons for upholding the award. Now, of course, contrary to what some pessimists may think, there is always a desire to uphold awards. If you otherwise find it fine. I think at some stage I had taken a decision. My memory is very poor. I don't even remember the case that Dr. Saraf was referring to, where I think I'd held this, that when a clause is not interpreted, of course, interpretation is also in the domain of the arbitrator. If two interpretations are possible, the judge would always cede to the view of the arbitrator. But what happens when cases where a clause is not interpreted at all? It is possible that a view can be there. And here, as I said, I'm not expressing a view from the arbitrator's point of view, but from the judge's point of view, is that if the clause required no interpretation, it required merely to be applied, then what is the point in setting aside the award? Here's the result in any case. Now, that's why I'm saying two big problems. No power to remand, and you cannot uphold the award on the same ground. Now, again, contrary to what some pessimists at the bar may feel, judges experience a lot of anxiety when they deliver judgments. And believe me, that anxiety is equal, if not greater in certain cases, in the case of arbitrators. Why? In the first problem which I mentioned, namely that the scope of challenge to an award is very little, is very limited. The anxiety is, what if I am wrong? My award may still be upheld. There's no pleasure in your award being upheld if there's a problem there. And believe me, judges are happy to have their views overruled, their judgments overruled. There's a wrong notion that judges are sensitive about it. So as an arbitrator, you feel, oh gosh, if it was in an appeal, the appeal court would correct my decision. If the appeal court is wrong, the Supreme Court is there to correct the decision. That level of comfort is not there for an arbitrator, and therefore the anxiety for an arbitrator to give an award which is sustainable is greater. The second scenario is the disastrous consequences of an award being set aside. And that is what we need to discuss today and interact between ourselves. What can we all do to make awards that are upheld? Now, I'm not saying this because there's any ego in having your award upheld or your judgment upheld. Believe me again, please, when we say that judges are not worried about their judgments being overruled. Because you know that just because a judgment is overruled, it doesn't make it wrong. And just because it is upheld, it doesn't make it right. That is the system in the hierarchy of courts that we follow. In fact, on a side note, we are used to criticism. I think the very first year in which I became a judge, I was a party to a division bench where the judgment was criticized very strongly by the Supreme Court. So if you feel that you were wrong, accept it. If you feel you are right, live with it. And we all know as judges and as arbitrators, as Justice Lodha once told somebody, he said, on an average, 50% of people hate us and 50% of people love us. I remember I was at a colleague's wedding when one of my chamber colleagues came up to me and said, something very amusing happened. So what happened? He said, I met a client after a long time and I asked him, how is your litigation going? And he said, oh, the litigation was going fine all these years till that stupid Parsi chap came over here. He doesn't know any law. He can't write English properly. And he's messed up the entire thing for me. Now, at that stage, I think there was only one Parsi. So by elimination, method of elimination, that was the gentleman standing before you. Now, that is actually, if you take it in the right spirit, it's fun. So judges don't have a problem about being criticized at all. The anxiety to make a sustainable award is for the benefit of the litigant. Now, this is where I say that when it comes to experience, or experiences rather, it's an ongoing exercise. I will share a few in the hope that in this ongoing exercise, all my other, colleagues and friends who are arbitrators will share their experiences with me. And I look forward there equally, as did Dr. Saraf, to the interactive session. I'll quickly run through 4 or 5 experiences that I have. Keep in mind always the adverse consequences of an award being set aside. I find that a time has come where it is absolutely essential for us as arbitrators to decide every point that is urged. In short, we should, as arbitrators, avoid shortcuts. You may agree with a claimant or a respondent on a particular point for more than one reason, for 5 reasons. My view is that you must then hold in their favor for all 5 reasons, not just on one reason and have a shortcut. Because as Dr. Saraf has explained to us, the award may be set aside on that ground if you leave it to just 1 ground or 2 grounds. I think we then owe it to the litigant to decide it on all grounds, because your 3rd, 4th, and 5th reasons may appeal to the court, and that may be enough to sustain the award. Now look what you've done if you don't do this, if you take a shortcut. That poor litigant has to go through the whole gamut, expend money and time for a fresh arbitration or for a suit. That would be unfair. So when you deal with every point, you have a greater chance of the award being sustained and saving the litigant. Similarly, I find that it has become necessary to deal with alternate cases. So don't take a shortcut. I shouldn't take a shortcut and decide on only one point. Take an example of mitigation. You will find in cases under the Contract Act that very often the respondent would set up the plea that the claimant failed to mitigate, and therefore, under Section 73, he ought to be denied damages, although he has proved breach. So if you are in his favor in mitigation, don't stop there. Then I think it is our duty to take the alternative case that where claimant pleads that assuming that I have a duty to mitigate, I have in fact mitigated, or that it is not possible to mitigate and therefore I don't have to mitigate. Because your award may be set aside when on the ground that you have held of mitigation. But if you're also with the claimant on the ground that he has in fact mitigated and you don't deal with that in the award, you're being unfair to that litigant because again you're putting him through this whole gamut of litigation. So the alternative case should be taken. And as I have been thinking about it, I think a time has come when we as arbitrators must also consider the alternate case, the case in the alternative. So it's not just a point in the alternative, but a case in the alternative. And the best example I can think of is under the Specific Relief Act. Say you're with the claimant and you grant specific relief. But think of the possibility of the award being set aside on that ground. I'm not sure, but I think it is worth considering as to whether then in the alternative, you should not also deal with the claim for damages. So you have the usual prayer for specific performance, and in the alternative, damages. Should you not also consider the case for damages? Because the doctrine of severability has been accepted, albeit to some extent. Who knows? Judicial thinking, judicial experience might come up with a case of an acceptance of an alternative relief. And I don't know what the position is going to be, but it is possible that the courts may say that although I think that the award ought to be set aside insofar as it grants specific performance, the award can be upheld on the alternative relief of damages. Again, and I'm sorry, it's at the cost of repetition, if that happens, you're saving the litigant the entire gamut of a fresh litigation. Another suggestion, which I find is, but a slightly different way. It's not as academic, but it is a very practical one. Dr. Saraf referred to interim orders. Now, I found that interim orders, though not theoretically any part of the final award, have an important bearing on the final award or on the outcome of the reference itself. But here you have to be very careful. Careful not to give a party an excuse to say that he is biased, he's already made up his mind, which is likely to happen. That's why you have to be very careful when it's not like as a case of as when we were judges, because assignment changes. So you come up with an interim award, etc. That's why, in fact, on a different topic, there seems to be a strong case for arbitrators holding only on the interim reliefs. But that's a different issue. We can still do it ourselves also, being careful. Now, a carefully prepared interim order could give the litigants the impression that, look, there is a lot to be said. We don't know which way this arbitrator is going to hold. There's a possibility he'll hold against us. There's a possibility he'll hold in our favor, but who wants to take the risk? Let us try and settle. Take my word for it. There have been settlements on that basis. When they realize that everything is open and this is going to be a protracted ad hoc arbitration or even an institutional arbitration with a time limit, they don't want to take the risk. They go for a settlement. And nothing is more satisfactory than a final award which is based on a settlement agreement. At the end of the day, that is what you want. you want a litigation to end. I have personally found interim orders to be a very important tool to bring parties not only to first to the negotiating table and then to settle the matter. It would not be proper on my part to give you examples, though I wish I could, because that really illustrates how beautifully interim orders can end the entire reference. Now, I know there has been a lot that has been said about institutional arbitrations, and one of the main service that they give you is a very strict audit of the award. Now, I don't have as much experience as many of my colleagues in international commercial arbitrations. I took up a couple of them at the instance, in fact, of people like Mr. Dwarkadas and Mr. Khambata. So I will not be able to tell you anything from personal knowledge. But from my discussions with arbitrators, both from our country and other countries, I would suggest that before just blindly getting into the concept of institutional arbitrations, we need to speak to them. But vetting awards, because they say that there's an audit. Now, let us assume that the audit is very strict by the institution. They go through the whole award. They're supposed to go through the entire transcripts and the documents and then tell the award, oh, you've missed point A, you've missed point C, you've point some other points. Have you considered this? Have you not considered that? No. Well, the question is, what do you do in ad hoc arbitrations where there's no institution conducting the audit? One thing that you can do is this. Put the draft award, especially in a very heavy matter. Some of these construction matters, for instance, you have 20 issues. Each issue is like a reference. So when people say, oh, you take so long over it, well, each issue is like a reference. When you start doing those, you'll understand. It's a trial. Each issue is a separate trial. You can put the draft award on the table and invite the advocates of both the sides to see it, not for the purpose of re-arguing the case, but for the purpose of telling you, you've missed point A, you've missed point B, tell us. And then record that. Many ways, that is, in fact, I find it more effective. Because when you have written submissions dumped on you, and that's another thing, I think written submissions must be given before the arguments are concluded. Otherwise, there is a habit, I'm sorry to say, of dumping in all kinds of authorities, submissions, judgments, and then saying, oh, look at to the appeal court. Sorry, I wouldn't say the appeal court. Now I have to say to the arbitration court, then look, they've missed this point. Here it is. Here's the evidence this point was taken. But there are lots of points which we know as advocates, and I'm sure the Advocate General at least would support me on that. I hope he would. That points which are taken in pleadings but not pressed. Now, it would be unfair to an arbitrator, it would be unfair to a judge, then to a complaint that this point has not been dealt with. So that is one other technique which we can use to obviate these challenges. And then the role of the bar. In fact, I told them yesterday, all the members of the bar who was kind enough to help us, guide us, that look, don't let us have a spontaneous exchange. Throw everything at me. And I told them half jokingly, don't call me a fool, but please feel free to go round and round and show me that I am one. So I remember H.M. Sirvai, another legend. He was invited, surprisingly, to speak at a function where the Chief Justice of India had come. H.M. Sirvai, very much like the Advocate General of Gujarat, Mr. Thakur, not just brilliant, not just erudite, but courageous, forthright, blunt to the point of being blunt. He was criticizing us judges, not us, I wasn't a judge, I was too young. And he said, there was a time when we could tell our clients with a reasonable degree of certainty as to what the outcome would be, but who is to account for the wise men in Delhi today? Now, he said this in the presence of Chief Justice of India, and only he could, I think, and then get away with it. But he made another point immediately, and that's where the balance of these great people come. He said a judgment can only be very often as good as the assistance given by the bar to the bench. And I think the bar really needs to assist the arbitrators, because remember, arbitrators are not just doing interlocutory applications, writ petitions, appeals. They are doing a final trial. The level of preparation must be outstanding. The level of preparation from the bar would have a direct correlation to the quality of an award. I also agree with many of the suggestions that Mr. Saraf made. We will keep them in mind as arbitrators. I think I've already exceeded my time. We look forward to any interaction from you all. If you have any suggestions, as I said, these are only few suggestions. This is an ongoing process. And may I once again thank all of you for the opportunity you've given us for sharing our views. Thank you.
Thank you, sir, for that engaging reflection. May we invite on stage Mr. Jay Kansara and Ms. Priyal Parekh, our colleagues at the bar, to join the guests for an interactive session with the speakers.
So let me begin by saying that it is our absolute honor and privilege to have both of you here today. And when Justice Wazida referred to the fact that there are difficulties and challenges being faced in terms of the preparation of award or for the purposes of its quality and standard, may I just begin by asking you, sir, that during your tenure as a judge, I'm sure you must have had a tremendous number of cases where you would have seen the challenge against the award under Section 34, as well as under 37 also. According to you, where do you think that the awards were lacking otherwise in terms of the basic test, or the fact that there were issues that you found that, oh, this is something that needs to be corrected otherwise?
I don't think I set aside too many awards. I think it may not be proper on my part to deal with cases that I myself dealt with. So if you'll pardon me, I won't mention those. But let me give you an example where I think where a judge who otherwise would be very hesitant to set aside an award, set aside an award in a celebrated case where he found that and all three Supreme Court judges, he found that the approach taken was that, all right, this is the judgment of the Supreme Court, but I prefer this view. Now, side. But that's a very rare thing. I have, at least in my experience, never come across any award which has gone to the extent of saying, no, I don't. I think I'll avoid answering it as far as my own judgments are concerned. I have set aside a couple of judgments, but sorry, a couple of awards, but that's very, very rare. I think must be just a couple of them.
Fair, fair. Otherwise, now when you sit, now, sir, when you have the stage where you sit across the aisle now as an arbitrator, what according to you should be the method or probably the manner in which an award should be drawn to have these standards of global legal system also acknowledging and accepting it? Do you think that that is something which is required to be looked into?
Sorry, can you repeat that last that global?
So overall, now since we are looking at the arbitration as far as Indian mechanism is concerned on a global standard, on a global platform as well, keeping that factor in mind, as an arbitrator, what according to you should be the method or manner in which you think that an award can be drawn to have that acceptance across the globe, otherwise in the legal system?
Across the globe, I think by and large, the parameters should be the same. I think Dr. Saraf in his address has dealt with all the items, in fact, which go up to making a sustainable award. I think that there's a far greater hesitation to set aside the award in places like Singapore, I'm told. Again, it's not on personal knowledge, but I am told that there's a lot of hesitation. It would require a court in Singapore a lot to set aside an award. So, but otherwise, I mean, from what I've been discussing in the recent matters which I did, for instance, with my colleagues over there, it's by and large the same, that you just have to take everything into consideration. But there's a slight difference. This is where I have a problem in the what they call the memorial system, and when you have rely so much on written submissions. So much is given up, so much is tweaked by the advocates during the arguments. Now, when you have this institutional arbitration of, where you spend 20 days on your own preparing, but you have written and very few days of arguments. In 8 days, you finish the entire trial and arguments. But there are so many points which are not pressed. What about those? I mean, I find that I would be struggling with it. I think I would pin the advocates down. Are you really keen on this or not? But otherwise, I can't see it being different globally. It's a time period, the systems, etc., which they don't like. But there, I must tell you, once again, I think the bar itself, a lot of them want an ad hoc system where they get a full opportunity. Now, a group of youngsters told me, so it's all very well to say that in 10 days, 15 days, we finish the entire arbitration. He said, but there are certain arbitrations where the clients also want a full-scale trial and the full-scale hearing, but with the benefits of an arbitration. Because they said, keep one thing in mind. As far as arbitrations are concerned, because of the narrow scope of challenge, this is the litigant's last chance. It's not a first chance. So there's a point of view there. I'm comfortable with both.
So my question is to you, Dr. Saraf. You stressed on the importance of procedure being the cornerstone of rendering a good arbitral award. And you gave us those examples how some issues in leading evidence and recording evidence led to the award being set aside. So I think, can these issues be addressed by well-drafted procedural orders during the course of arbitration? What are the points to be considered while passing procedural orders in an arbitration?
Yes, that really is very helpful because well-drafted procedural orders, as I said, first thing is to set out the procedure of the arbitration right up front. What are the rules that are going to be followed? The rules of the game can be set out right up front. As I said, in an institutional arbitration, that may be minimal because the rules are already set out in the institutional rules. But yet, every concession made by a party, if a party at any stage indicates that he is not pressing any claim, as Justice Wazir said, it is important that it is set out in the procedural order, and at times it may be appropriate and better if that memo giving up that claim or not pressing that claim is taken from the party concerned. Because the fact of the matter is, in our country, arbitrations go on for years. At times, there is a gap of days and months between two hearings, and very often the arbitrator loses sight of what had happened. Even the lawyers sometimes forget about it. At times, there is a change of lawyer in between. So it is very important that procedural orders are watertight. Details of everything that have transpired is recorded in the procedural order. It will also help the arbitrator trace everything at the time of writing the award.
Right, sir. So one more issue that you touched upon, very basic as such, the section 31, which talks about the importance of date, place, and signature in an arbitral award. You also indicated that we'll discuss this more during the interaction session. So, can you give us some examples or to explain the relevance and importance of why this needs to be there in an award? Like, what is the intent of the legislature in ensuring that these criteria are there? You indicated that awards are being set aside on this ground. So, can you give us some examples of why this is so important?
Okay. So far as signature is concerned, it's more, as I said, on an authenticity issue. And also it carries more relevance in a uh, panel of arbitrators. When it's a sole arbitrator, it's a statutory requirement. It needs to be signed so that its authenticity is not called in question, that this is, in fact, the award signed by the arbitrator. But in a panel of arbitrators, the signatures carry a lot of relevance because the Act says that if there is a panel of arbitrators, then the majority of the arbitral tribunal can sign the award so long as they record the reason of the third member not having signed. So, to that extent, the signature becomes important to decide, to show that yes, the majority has agreed to this award and that this is a majority decision. So far as the absence of signature of the third arbitrator or the dissenting arbitrator is concerned, reasons need to be provided as to why he has not signed it. So, that is to some extent the relevance of signature. So far as place of the arbitration is concerned, the Act uses the word place. In the 2024 bill, rightly it has been recommended that the word place should be substituted with seat because a lot revolves around what is the seat of arbitration. The jurisdiction of the courts which will consider a challenge or any further proceedings arising out of that award is determined by the seat of the arbitration. So, therefore, it is important to set out clearly what is the seat of the arbitration. So, place of the arbitration really is in the nature of the seat of the arbitration, unless the arbitrator states that this is the place of the arbitration in a very different way. But the real purport is the seat, and that is apparent from the 2024 Act, which seeks to substitute the word place, or sorry, not Act, but the bill, which is not yet passed, which seeks to substitute the word place by seat. So that is the relevance of place or seat. Because if a 34 petition is to be filed, then courts have now held that it is the courts where the seat of the arbitration was which will have jurisdiction to consider that proceedings. And as a result of not mentioning of a place, a lot of controversy goes on as to what is the court which will have jurisdiction to try the 34 petition. And the other thing which you said is signature, place, and date. Date is really a point which crystallizes the date on which the arbitrator has passed the award, though that really is not of much consequence in the sense that the time to challenge begins from the date of delivery. But there was a very interesting case in Delhi where a date was mentioned in the award which was signed by the majority arbitrators. And that award was challenged before the Delhi High Court. It so transpired that this award, which was signed by two arbitrators and a date was mentioned, was sent thereafter to the third arbitrator for his view. So it was held that considering the date which is specified in that award, it is really not an award, but it was a draft sent for consideration to the third arbitrator because till the third arbitrator has deliberated upon it and also participated in the deliberation, it cannot be an award at all. So there, as I said, each of these aspects have led to litigation. So there are situations where the date becomes relevant to determine whether it is really an award passed or it is only a draft. It was a interim thing which was under consideration. So these are the kind of things which arise. And as I told you, it's interesting. I have today a note which has 6 pages of only judgments on these 3 aspects. So we spend a lot of time litigating. Lawyers, innovation has no end, and therefore we drag the matters which are supposed to be out of court in court.
Lawyer's ingenuity.
Yes, it is, and a lawyer's delight also. I just wanted to add on one point, sir, if you permit me. Justice Wazifdar mentioned about review of an arbitral award by institutions. It's a very healthy, no, not review on merits. I'm not talking of a review on merits. It is just to see whether the award complies with procedural requirements. It has dealt with issues. It has answered all the points for determination or not. SIAC has I think, a procedure where the award goes to first a review committee, which then considers, it does not tell the arbitrator you are right or wrong on this decision. It basically tells an arbitrator these issues remain to be decided, these issues need to be decided. Now, I have one question which I would like to put to everyone here. We need to have a change of mindset. The arbitrator pool in our country, which comprises of some of very high judicial persons who've held very high positions, at times are willing to have that exercise done by a foreign institutional arbitrator institution. How many of them will be willing if their award was put to such audit or scrutiny by a domestic institution? And that is where a mindset change is required, where our arbitrators will also have to be open to a scrutiny being done by a domestic institutions, not as a sitting over their decision, but as an assistance of telling the arbitrators that this issue needs to be dealt with, this issue has not been answered, these aspects which were argued have not been dealt with, and that has to be taken in a spirit of assistance rather than supervision. Once we do that, I think it's high time that Indian institutions also introduce that kind of audit.
I'm going to get into a boxing match with him on this one.
Sir, let me tell you one thing before you answer that. The pool of the arbitrator, you are hardly reflective of the pool of arbitrators. So, with your modesty and with your approach, you are not the entire reflection of the pool.
I'll just tell you, I don't think there is going to be any hesitation. In fact, it is more welcome, because the only thing is, I would really like to know, as I said, I don't have experience, but I'd really like to know what the quality of that audit is, etc. But I would be, in fact, delighted if that's why I said why the institution placed the draft award before the very advocates who have argued before you. In fact, be happy to say that they eliminate all problems.
That's a very difficult practice in a country. And I can understand some very responsible senior lawyer looking at your draft award and telling you, sir, these are some errors. Otherwise, I would not support placing an award before the lawyers in advance and asking for whether all issues have been dealt with or not, because it can be abused at times, sir.
I mean, I have complete confidence. 8 years almost since I retired, I've not had one bad experience from any. Perfect. There's no problem. And as I said, they are not going to tell you whether you decided right or wrong. They'll only say, so you've not dealt with this point. Would you like to deal with this point? You've not cited this judgment. Would you like to deal with this judgment? Right, that's a very good audit system itself.
No, as I said, so it depends on.
So moving forward, so otherwise, so yes, this is something which is a regime which would be system driven otherwise, and more often than not, it is going to be depending upon who the parties are or who the lawyer is appearing before a particular tribunal. I think that would take much of a precedence otherwise. Now, so moving forward, we have seen in many arbitration cases where the tribunal is inclined towards granting interest and cost of proceedings. In our system, in our country, otherwise, in courts, generally, we have seen that cost is something which is not considered that seriously otherwise. But in terms of arbitration, in parlance where parties are actually litigating before the tribunal, according to you, what would be the consideration for a tribunal to grant an interest or cost, for that matter of fact, in an arbitration otherwise?
Okay, let me answer that in a way which I know that this audience will appreciate. When it comes to interest, muddal karta vyaj valu. You go on that principle. But having said that, at the end of the day, you have to decide it in accordance with law. If you're allowed interest, why not? Because look, I mean, ultimately, it is the interest that makes all the difference. Our sayings in our own languages are actually far more descriptive than anything you can find in the English language. Muddal karta vyaj valu sums up the whole thing. Right? And I remember my senior, Rohit Kapadia, whenever there's a ticklish commercial problem and I couldn't get the answer, he would always say, Shavaks, stop thinking like a Parsi. Start thinking like my community. Then you will, he said, Parsis find a problem, Gujaratis will find a solution. That's what he used to say. So,
Very well said, sir. Very well said.
but- so see, arbitrators, especially, I remember Mr. Cooper saying that, a good commercial judge or an arbitrator doesn't just read his books, he smells the problem. He should be able to sniff it out. So arbitrators, with I presume with their experience, a little bit does help over there. But at the end of the day, you have to look at the statute book. You have to look at the law. If it doesn't permit it, however strong you may feel about grant of interest, you can't grant it. There are contracts prohibit granting interest. You don't grant it. That is the bargain between the parties. At the end of the day, it is the contract that must prevail and the law.
Fair, sir. In terms of cost otherwise, as an arbitrator, what are the considerations that you would take into account for the purposes of granting or awarding costs, sir? Because in today's parlance otherwise.
Before you go further, I'll
Yeah.
tell you straight. I'll save you the energy. If you don't mind, I won't answer that. Because very often as arbitrators, things go on in our minds, which I would not.
I absolutely see that point, sir. If I can put this to Dr. Saraf, otherwise,
I think the Act itself sets out the guidelines for award of costs. And I think the power to impose costs should be exercised by an arbitrator, because otherwise what's happening is, my experience has also been that parties, eh, more so when there is no ad hoc stamp duty, makes all sorts of claims before the arbitrator. The inflated claims which per se are not maintainable in a commercial contract. A claim will be made of mental harassment, and that is pursued before an arbitrator. Now, when a valuable time of an arbitrator, and apart from that, the other party has also expended money in defending those claims, there should be a cost element in which should be awarded by the arbitrator, considering the principles which are set out in the Act, because now the Act has set out at great detail what are the factors which should be taken into account. I must share with you all, one of the factors which has come now in the Act is the refusal by a party to accept a reasonable settlement offer. So suppose there is material to show that on the 10th day of the arbitration, one of the parties had offered to the other side 1 crore of rupees in settlement. And if it is finally turns out that the arbitrator has only awarded 90 lakhs to that party, then according to the Act, that can be a ground for awarding costs, saying that after this date, the entire cost should be on you because you are getting more than it. And in international arbitrations, they used to have earlier a system of a sealed cover mechanism, where a party makes a settlement offer to the other side, and then in a sealed cover puts his settlement offer with the arbitrator. Arbitrator does not know what is the settlement offer made to the other side. At the end of the award, the arbitrator opens the sealed cover, and if he finds that the amount awarded by him is lesser than or rounding about the amount which was given in settlement, then entire cost of the arbitration from that day is imposed on the other side. So these are methods which can make arbitration more effective.
Sir, I think one last question from our end before we throw it open to the audience. One of the topics that we would like either of you or both of you to touch upon is regarding enforceability of awards. We are setting up a state-of-the-art institution here, and I think we would want not just domestic but also foreign arbitration to come in. So one of the questions is, how do we enhance the arbitrability, the enforceability of an award in an international arbitration? For instance, like, should we have a mechanism in place to ensure direct enforcement of probably interim awards rendered by foreign arbitration. Right now, we have to file a separate Section 9 application. There are institutions, international institutions where this is permissible. So this is just one of the examples. So can you just broadly tell us what can be done by an institution or by stakeholders in general to enhance enforceability of a foreign award here in India? Either.
The enforceability of a foreign award, if an award has been passed considering all the methods and all the safeguards which we have discussed, that will eliminate a lot of grounds of challenge to a foreign award in any case. Now, how is a foreign award enforced? You have to file a petition in our court or maybe take out execution proceedings, and the other side is given an opportunity to oppose the enforcement of the foreign award. And the grounds are set out in the act itself as to what are the grounds on which the enforcement of a foreign award can be challenged. A lot of them are procedural, etc. But to some extent, it is also dependent on the applicable law under which the award was passed. So, to that extent, there is no escape in going through that entire exercise. Only thing is that the applicable law might be different in a foreign arbitration. It might be governed by English law, it might be governed by some other laws. So, there you have to look into that law. And once the court has to scrutinize the entire award, otherwise, according to me, the tests are more or less the same.
Fair. So before just one last question, otherwise, we have seen that we are now still on that cusp of the old act and new act matters still being pending and being considered before the institutions or the arbitrators otherwise, whether ad hoc or otherwise. In a situation where in the old regime, let's say the final hearing is concluded, but the award is not pronounced for the longest of the period, for about 12 months, 15 months, 18 months probably. What, according to you, could a litigant do in that case? Because for that matter of fact, a party who has already participated in the proceeding, gone through the entire rigmarole, what Justice Vazidar also referred to, that it otherwise puts that litigant into a jeopardy otherwise, or in a situation where he is completely helpless for that matter of fact. In such a situation, is there anything that you would consider that as an institution or as an arbitrator, that there are steps which can be taken to avoid such a situation, sir? For Mr.
Dr. Saraf too.
Let me ask you one question.
It's a question which can directly come before me at any time.
29A has been introduced in the Arbitration Act, which sets out timelines for completion of the arbitration, and which also includes the timelines for passing of an award. And that provision sets out in great detail that while extending time, the court should apply its mind to see who is really responsible for this delay. Is it one of the parties? Is it the arbitrator? And if it is found that the arbitrator is responsible for the delay in arbitration, then there are consequences provided which the court can take steps in that regard. Now, we have all seen 29A proceedings. Does any court generally do an inquiry which is mandated under 29A? And we all are guilty for it. Let's not find fault with the court. We all lawyers also hold arbitrations in the evening, 1 hour, half an hour. Then as a club between both of us and the arbitrator, we all go to court and say, by consent, we are seeking extension. And we merely seek extension by consent. So ultimately, these delays in arbitration is a contribution of lawyers as much as arbitrators. So let's not find fault only with arbitrators. First, we need to question ourselves as lawyers. How much are we being contributory to these delays in arbitration? I have done enough arbitrations. Now I have reduced it substantially because I feel it is injustice to just go huffing and puffing after a whole day of court, reach before an arbitrator at 6 o'clock and then do it for 45 minutes and say today's session is over. Now one session, another after a month. So as I said, if we really want to make it effective, then lawyers should be effective in their representation before the arbitrator, and only then the courts will also be able to enforce 29A more effectively and meaningfully.
So this is after the introduction of 29A.
Yes.
In a situation where the provisions of 29A are not applicable otherwise for amendment.
There will be hardly any situations where awards which were there to 29A came into force in 2015.
15.
So now on all those pending arbitrations also really 29A became applicable. So today there will be hardly any situation where 29A is not applicable. Most of those awards would have been passed from 2015. So those are very rare situations now. If we can improve our time ahead, then we can live with some of those.
The audience is also very curious to ask certain questions, so we would like to open the floor to the audience. If the audience would, I can see
Hello.
there are mics which are.
Hello. Good afternoon, sir. From my side,
So what exactly do you mean by social engineering? Sorry. Social engineering. Effective execution of disputes. Let's take it.
hello.
Okay. All right.
Yeah.
Can institutional arbitration? Yes, of course. I mean, it depends on how the institution is run. It entirely depends on that.
In section 7 and 8, as per my knowledge, sir, this is useful or not? Regarding social engineering,
Well, I'm not going to comment on the legislature's wisdom, so
Vic-
thank you.
Mr. Juneja has a question there, so
Yes.
Mr. Juneja also.
To both the honorable guests. My question is with regards to the awards only. That's the subject was on the awards. It is seen that while the arbitration proceedings start, after the pleadings, there are terms of reference which are called for by the tribunal, and indicative terms of references are given by both the parties. Then the references are drawn, and final terms of reference or the issues are framed on which the proceedings go further. Now, most of the time it happens that certain terms, one party gave 18 terms of reference, another one gave 21, and arbitrator frames like 24 terms of references. Now, the proceedings, when they go on, in the award, it is always seen that certain reference terms of references are answered and certain are not answered. They can be conflicting even to each other. So what according to both of you should be the practice that at that stage itself, the question of, because if we go to the court and say that this is the terms of reference which were framed, this is not answered, and this is something which for which even the evidence was led, and still it has not been answered, court is definitely going into exercise the powers under section 34. But what should be the importance of that stage, that at that stage itself a proper filtration can be done and the award becomes less susceptible to the challenge.
It's a little difficult question, because if it is an issue that has been framed by the tribunal or by a court, it has to be answered, right? Now, if an arbitrator doesn't answer an issue which is by a crucial importance, significant importance, then that award is going to be challenged if he doesn't answer it at all, and that has to be answered. I mean, and I think that's pretty obvious. But how are you asking us how to avoid it? I mean, that
At that stage, how the filtration should be done so that issues are framed in that particular manner so that this challenge can be
I
avoided.
think what you mean is when you're talking of terms of reference, you are meaning points for determination.
Points for determination.
So let's take it this way. According to you, both parties give their draft points for issues, and there are some which are adopted by the arbitrator, some are not adopted by the arbitrator.
No.
So therefore, it is better that after taking the points for determination by both the parties, the arbitrator hears both the parties and then finalizes the points for determination right in the beginning. And here's the objection of the parties. The maximum effort of the arbitrator should be to accommodate both the sides' points for determination, unless something is not arising out of pleadings or something like that. Now, if the arbitrator, after hearing both the sides, crystallizes the points for determination, then those will be the points for determination which govern the arbitration. A party may later on have a grievance in a 34 saying, I have requested the arbitrator to frame this as a point for determination, but the arbitrator did not. And therefore, an important point was not considered. But therefore, it is better that an arbitrator accommodates as many points for determination as he can and frame it right in the beginning and record reasons for not having a frame certain issue which one of the parties had requested for.
Can I ask question, Lordship? Can I ask question, Lordship? Lordship, my question is that in my practical practice, I have faced one problem that my client has taken loan from the EU Small Finance Bank, which was for a vehicle loan. It was a HP hire purchase loan. He has taken this vehicle to the another person for a tenant rent. That person was not paying the rent, and that is when the cheating affair was registered before the police, and the charge sheet was filed. When the charge sheet was filed, at that stage, EU Small Finance has started the arbitration proceedings, and they have sent notice to my client to appear before the arbitrator. We have submitted charge sheet papers, full charge sheet papers before the RBI ombudsman to forward the EU Small Finance Bank. And in spite of having criminal proceedings, arbitration has passed the ex parte order. So can arbitration order can be passed in pending of criminal proceedings?
There are judgments of the Supreme Court which say that an act may have a criminal aspect also and also a civil aspect. Merely because there are certain criminal proceedings pending do not mean that arbitration cannot go on. So there are large number of cases where arbitration can go on simultaneously with criminal proceedings. Let's take an example of a partnership dispute. There is a claim of dissolution of a partnership and rendering of account. And one of the partner also has filed some criminal proceeding against his partner for having done something wrong. That does not mean that the arbitration cannot go on. So there are enough number of judgments. Now, we say that merely because some criminal proceedings have been filed, which is also connected with the subject matter of the arbitration, that does not mean that the arbitration proceedings cannot go on.
But sir, when the award of the criminal final judgment of the criminal court will be declared by a final verdict will be declared, that might be possible that the accused will be convicted, and right now in the arbitration matter, original complainant will be has to suffer.
Because the test
So at that time, whether it is possible that the arbitrator or award may be null and void.
not
It is possible.
necessary, because the tests in criminal proceedings are very different from a proof in a civil proceeding. And there are series of judgments which you will find going back many years that civil proceedings need not be stayed pending criminal proceeding. That is depending on case to case.
And one more thing, in the criminal proceedings where in such scenario when bank has given the loan, so bank has to help us to give the statement that we have given the loan and this vehicle is hire purchase from our loan. When bank is not ready to help us to become a witness in the criminal proceedings, so what is the remedy for that?
I'll answer that question provided you are willing to accept my memo of fees.
We can move to the next.
Yeah, so Honorable Mr. Oh, sorry.
I think this is.
Good afternoon, sir. My greetings to the distinguished dignitary there of the dais and all my friends over here. Uh, my question, before I come to my question, two of the observation I want to share. One is this entire conference is wonderfully organized. It is so nicely organized. Every topic, the speakers, and everything is done in a very nice manner. I am not going to give vote of thanks, otherwise I would have said more in detail. But today, the wonder came that in my academic career, I have seldom seen a person doing PhD in judicial intervention in arbitration. Really, it is something rare topic. And the rarest of rare is that such a rare speaker has been found out. And such a befitting subject is given to him. These are just kind of passing observation. My question is, sir, as we all know, the most emotional litigation among all the litigation is matrimonial litigation or say family suit, because there your heart is related, your emotion is related, you are concerned with the entire thing. It's not something like profit, business, or commerce. So that particular litigation, when takes very long time, every minute is a killing minute for both the sides. And therefore I was just thinking that can we do that all the matrimonial matter where parties are desirous can be given to arbitrator so that it can be solved early, and for that still less time limit can be kept. So what is your take on that? This is my suggestion which came in my mind for long, because family courts are doing their best. So what is your take on that, and what is Dr. Saraf's take on that? Thank you so much for the opportunity.
I will leave it to the academician, Dr. Saraf, to answer that.
Madam, it is now settled law that matrimonial disputes are not arbitrable, because the general principle is that any dispute which falls within the ambit of a jurisdiction of a special forum to the exclusion of a civil court is not arbitrable. And one of the examples which is always given of a dispute which is not arbitrable is a matrimonial dispute. So therefore, so far as matrimonial disputes are concerned, they cannot be referred to arbitration. However, mediation is one of the aspects which is being invoked regularly in family matters to try and see if matters can be resolved. So far as an alternate dispute redressal mechanism, mediation is invoked in family matters. Arbitration is not something which is legally permissible.
Good afternoon, everyone.
Sorry.
Refer to one of the mode is shown as arbitration.
Is in the civil procedure code which is applicable to various proceedings, not necessarily to matrimonial proceedings.
Yes, we have Justice Devani here who is seeking to ask a question. So, retired High Court judge, Justice Devani is also an arbitrator, and she would. Yes.
The matters that so in most of the matters, they ask for interest at the rate of 18%. My question is directed to Mr. Saraf that they normally ask for 18% interest, and even if you ask them to argue on the basis for that 18% interest or any interest, they don't argue. Then what does the arbitrator do? I mean, then it's not, then I have to work out on my own. I have to find out what would be the normal rates, bank rates, etc., and then work it out. Now you say that then that is something which I have not put to the parties. But when they have not answered a question, what do I do then?
That's an important question because parties claim 18%.
Yes.
And I have seen arbitrators at times saying, well, the respondent in the counterclaim has also claimed 18%. So if he has claimed 18% against the other side, he also considers 18% as reasonable. So that's a very thin line, according to me, to say that because both parties have claimed unreasonable interest against one another, unreasonable interest can be granted. You are right, madam, that most often parties don't lead evidence on that. So, as I said, the courts do not require too much of a reasoning from the arbitrators for grant of a reasonable rate of interest. If the arbitrator has granted in the range of 8%, 10%, 12%, hardly any court interferes with that kind of a grant of interest as a unreasonable rate of interest. So mostly it is when it crosses 12% or it is given on a compounding basis or something that it is wrong. An arbitrator is surely entitled to put to the parties that can you get me the prime lending rate today? If not, the arbitrator can put it to the parties saying this is the material available in public domain of the prime lending rate. I'm putting it to you all. Do you all have anything to say about it? If they don't say about it, that's a basis.
So I have to, because that would come at the stage of award.
That's an apprehension if you have
Yes.
that it might be told by the court that what material you have relied upon. That can be
No.
easily undone at the stage of hearing only.
That normally would be part of my order, that
It is so much.
so much
But that's a
mention about
public
it.
domain document.
So that's how I do it. But that's what I wanted to know. I mean, since you said that without putting it to the party, you should not include it in the award.
There are matters and matters. I don't think this is a matter where courts would generally interfere, where a grant of interest of say 2-3. Because another point I must tell you is that post award, the act itself says 2% beyond that. So that is already considered as a test
Yes.
in the act for post award. So adopting that test for pending arbitration also would not be unreasonable.
So the other thing is arbitrations go on for such a long period. Like there'll be one hearing and then normally because the advocates do not have the time, it goes on after 15 days after. So there might be a gap of even 2 months between two hearings. So it's not humanly possible for the arbitrator to have gone through every documentary evidence at the time when the arguments go on. So certain points you realize only at the stage when you're making an award that something has been missed out by the advocate. At that point of time, how do you put it to the advocate then?
You can always issue notice to both the parties
Okay.
and call them for a further hearing. Till the award is passed, it's always open to an arbitrator to call them for a further hearing.
Thank you.
Before I ask my little question, I joined with my elder sister, Dr. Jyotsna Agni, that this is a wonderful sessions and especially organized by Honorable Patron in Chief, Honorable Executive Chairman of the Gujarat State Legal Service Authority and their team. So once again, we learned so many things and we are learning so many things. Belot, my little question is that Section 89 contemplates 4 different modes so far as the ADR is concerned, if it appears to the court for settlement, right? That arbitration, there's judicial settlement, lok adat and mediation. Now the trend has come that mediation in arbitration. So how far the mediation in arbitration justifies? All the 4 modes have independent and autonomous procedure. So my request is that how far mediation in arbitration?
I think, brother, this is going to be taken up by the Chief Justice in the next session.
Please.
I think that will be.
Please,
it'll be-
Honorable
yeah.
Chief Justice next
Thank you.
session. So.
My question to Justice Wazirdar is this. My question to Justice
Honorable
Wazirdar.
Mr. Justice P.B. Majmudar.
Yes. The Arbitration Act provides that the arbitrator cannot act as a mediator. The Act provides itself that you can't, in the sense that party may not fail, that I have prejudged the issue. But in order to encourage the settlement, of course, when the evidence is completed, can at that stage arbitrator put to the party that as per evidence and as per law, this may go against, it is better you settle, whether such type of query can be put to a party or not.
Brother Majmudar, I think I would personally find that a little bit of a risky approach. You can always broach the settlement in a different way, a way which is neutral, which doesn't, because the moment you disclose your mind, then it becomes a problem.
Even at the stage of final argument.
I would hesitate to do that.
That's
I mean, the Chief Justice's session will be dealing with it in more detail, but personally, as I said, we have to use our experience to be a little careful as to how we enter into Section 30, subsection 1, without giving any cause for grievance or even cause for mischief. Once you disclose your mind, you have to be really careful over there.
That's true. And the Chief Justice, my another question is, while deciding Section 9, to what extent you can go, whether you can go to balance of convenience, etc., or
Years ago, I gave up that right.
my last question to Justice, Mr. Sharaf is that will you agree with me that the agreement provides 3 arbitrators normally responsible for delay in deciding the cases because of diary of each of the arbitrator, etc. And whether law is required to be amended by Parliament on this basis, leave it everything to Section 11 to the Chief Justice or is designated to decide only sole arbitrator.
Whole basis of arbitration is that the parties have a autonomy to decide their tribunal.
That Act provides, that is why.
So therefore, the Act cannot dominate the will of the parties. In fact, sir, if you see the Arbitration Act, invariably most of the provisions begin with the words unless otherwise agreed by the parties. So the whole basis of arbitration is party autonomy. They decide what is the nature of tribunal they require. And it will be difficult and maybe impractical in an arbitration to force a nature of a tribunal on the parties. You're right, sir, that could be one of the causes, but that is only one of the causes. There are many other causes for delays. As I said, parties are contributories, lawyers are contributories to the delay. Every stakeholder is a contributory to the delay in the process of arbitration, not just the panel of the 3 arbitrators. If the 3 arbitrators say, we will sit continuously for 10 days and hear you both, are the lawyers agreeing? Then why find fault only with the tribunal? So, sir, each of the bodies, each of the stakeholders in their own way are contributing to delays. Sir, I would like to tell you about a very interesting incident about one of the arbitrators in Bombay. She shared a very interesting incident about a settlement part. She said that after signing the award, I call both the parties for delivery of the award. I put the award in a sealed cover before both of them and say, this is my award. I am going to deliver it to you. Before I do that, are you willing to settle before me? In the sense, whatever you all say now is not going to change my mind because my award is crystallized and kept on the table. If by the end of the day you all settle it, I'll tear off this award. If you all cannot settle it, then I will open this package and hand over the award to you all. I found it as a very novel way of encouraging parties to settle a matter. So I just wanted to share with you all a methodology adopted by one of the arbitrators to encourage parties to settle.
My question is to. Sorry, we are.
One question.
We are running short of time. We can only entertain one last question because okay. We'll let the guest choose the question for them. The person who has.
You've been standing up for a long time.
be
Go ahead.
Thank you so much. Firstly, I would really like to appreciate how both of the panelists have been discussing the scrutiny process taken up by the arbitral institutions. And I myself working for one. So I work for Mumbai Center for International Arbitration. And I really appreciate that this has been acknowledged that the whole process we take to scrutinize the award. So now the question being,
Criticize the MCIA. Please remember that Mrs. Sachdeva is sitting right here.
I really appreciate what we do. But yes, so my question is to both the panelists. So the question is, in case an award is set aside, do you think that an arbitrator should be required to refund the fee which has been paid to them already?
Let me answer that question with a question. Okay? There are about 30 or 40 people sitting over here. Ask them the question that suppose their judgments are overruled, should they return their salaries? It's like that.
Should have seen that. Okay. But no, so the question is coming from a point of view that, for example, the number of hours the arbitrator has spent during the whole arbitration hearing and the process. And and another instance which Mr. Like one of you mentioned that by the end of an arbitral process, when an award is being passed, and if the parties
choose to negotiate and settle the matter, what should be and how should the arbitral fee be decided?
All agreed to upon the beginning itself. So where is the question of saying how is it to be decided? Right?
Thank you so much, sir.
Thank everyone in the audience for your
I have a
questions.
last question.
A very good noon to Honorable Justice S.J. Wazifdar.
I'm sorry, but
Sir, we are running.
We'll not be. We are running really short of time. We won't be able to entertain any more questions. We are really sorry. We will probably call him again. Once again, we hope the privilege of having him again, so that any unasked questions can be asked at that time. But Tanay, can please.
Thank you, Priyal. Thank you, Jay. We now take a moment to thank our speakers. May we now request Honorable Mr. Justice Ilesh Vora, Judge, Gujarat High Court, to felicitate Honorable Mr. Justice S.J. Wazifdar, former Chief Justice, Punjab and Haryana High Court. May we now request Honorable Mr. Justice H.D. Suthar, Judge, Gujarat High Court and member of the Building Committee, to felicitate Mr. Birendra Saraf, Senior Advocate. Thank you. With that, we conclude the first session. Let us now take We request everyone in the audience to please take their seats. Hello.
May I once again request everyone to please take their seats.
We request everyone in the audience to please quickly take their seats. Welcome back, everyone. We are now at the last session of this conference. The topic for today's session is Evolving Hybrid Models of Dispute Resolution. It is my privilege to introduce Honorable Mrs. Justice Sunita Agarwal, Chief Justice of the Gujarat High Court. Her ladyship began her distinguished judicial career with her elevation to the bench of Allahabad High Court. After more than a decade of notable judicial service, her ladyship was elevated as the Chief Justice of our High Court in 2023, thereby becoming only the second woman Chief Justice of the Gujarat High Court. During her tenure at the Allahabad High Court, Justice Agarwal delivered several landmark judgments across diverse fields of law. In her present role, her ladyship has continued to make significant contributions, particularly in arbitration jurisprudence, while also providing exemplary administrative leadership. Justice Agarwal has delivered several important rulings clarifying both procedural and substantive aspects of arbitration law. In the case of Instacart Services Private Limited versus Megastone Logipark Private Limited, her ladyship addressed the important question of seat versus venue of arbitration. Although the agreement provided that arbitration would be conducted at Bangalore, it also contained an exclusive jurisdiction clause conferring jurisdiction on the courts at Ahmedabad. The court held that the reference to Bangalore was merely a designation of venue and not the juridical seat, and that the exclusive jurisdiction clause constituted a strong contrary indicia. The ruling reaffirmed the primacy of contractual interpretation in determining seat and clarified that jurisdictional clauses must be read holistically to discern the party's true intention.
Her ladyship is also a staunch propounder of mediation, and under her leadership, the Gujarat High Court has also recently hosted a two-day national conference on arbitration, bringing together eminent judges and senior advocates from across the country, aiming to help the members of the lower judiciary as well to deal with the bottlenecks in execution of arbitral awards, highlighting contemporary challenges and a way forward for the future. Her leadership at the Gujarat High Court continues to play a pivotal role in strengthening India's arbitration jurisprudence and commercial dispute resolution framework. We also request Mr. Jay Kansara and Ms. Gargi Vyas, assisting advocates, to accompany the learned Chief Justice on the dais.
We now request the Honorable Chief Justice to please start the session.
A very good afternoon. This is on. A very good afternoon. I think after a sumptuous lunch, tolerating me would be another issue for you. But actually, I must tell you, today I am in a different role. I myself is at a crossroad. Today I am sitting in your court and you will be judging me. So I know that, and I can't help it also, that every day while hearing, I'll put a lot of questions to you. And many a times, I bother you with my questions. So today you are free to bother me. And I'm nervous in appearing in your court, putting my perspective, which actually is little bit creation of my mind. So you will be judging me on my perspective also. You will be critical of my views and you will be putting your points across if I say something wrong before you. So today I'm not here as a Chief Justice of the Gujarat High Court. Today I'm here as a speaker, presenting my point of view with my perspective, which is actually, it's not actually my perspective, I must say, but it is my perspective which has evolved over the period of years, being a mediator, being a practitioner, and being a judge for 12 years. So again, very good afternoon to you. The topic which I am going to cover is Med-Arb, Arb-Med, and Arb-Med-Arb as well. So when we are talking about Med-Arb, Arb-Med, and Arb-Med-Arb, I think there are some issues about it. There are some reservations which I have come across while talking to people and while putting across my point of view, that they have some reservation about Med-Arb and Arb-Med and Arb-Med-Arb. But in Gujarat High Court, we have established Med-Arb Center, which till now we have named it as a Med-Arb Center only. But I'm looking forward to rename it as Med-Arb, Arb-Med, and Arb-Med-Arb Center. So the first thought process which I came across while preparing for this session is putting my perspective why it is needed. I'm not giving you any legal perspective about it. I'm just giving you a human angle of mediation and why mediation is needed to be integrated in arbitration. When I came to Gujarat about 2.5 years ago, though I had some idea about this society of Gujaratis, but I did not have a fair idea as to what is their perspective about life, what is their idea about life, what is important to them for themselves. I'm born and brought up in UP, in the eastern part of UP. So in our state, like we used to deal with very small matters relating to rural area, where because of a very small dispute, some criminal act was done. So there people say that Judge Joru's Zameen, 3 things were very important to everyone in their life, for themselves. When I came to Gujarat, you may correct me and always dispute me, but then my perspective is that for a Gujarati, 2 things are important: their business and their family. So, as the Chief Justice of the Gujarat High Court, I thought that since I have been given this responsibility by the grace of God to head this institution, to deliver to the society, I must do something about these 2 areas which were definitely taken forward, but according to me, were left out for some reasons. So, while dealing with these commercial, I must also place it on record that when I came here, then I started dealing with commercial disputes for the first time. In UP, we did not have this kind of litigation in commercial matters and especially in arbitration. So when I was dealing with arbitration on Section 37 appeal, then commercial matters, Section 13 appeals, then 227 petitions, then I realized that we are not delivering to the society actually. We are lacking in our duty to deliver to the society to some extent. Then I also realized that there are some matters where people actually do not want us. They do not want adjudication. They want an alternative dispute resolution. They want to end their dispute, but they are stuck in the court. They are stuck in the court because they have entered inside the courtroom. They went to a lawyer. I don't take offense, I'm not imputing anyone. I was also a lawyer. They went to a lawyer. Lawyer suggested him that this is what you can do. Because lawyer actually has to suggest only legal ways, legal solution of disputes. And then they are there. Then they came with some idea that they will get justice, they will get solution. But as yesterday, Mr. Janak Dwarka Das has very validly put across that our commercial courts are not able to deliver the way they were supposed to. In Gujarat, we have commercial courts, established commercial courts. Additional district judges are doing the Section 34 matters, commercial suits, they are deciding. But to some extent, because we are already the docket management, docket inflow, institution disposal, other matters, vacancy, there are many issues which I'm not supposed to discuss here. So then when I was doing Section 11 arbitration applications, and I did it personally because I wanted to know as to how our arbitration center is working. then I realized that in many of the matters, they actually did not want to go to the arbitrators. They wanted their solution. So gradually, I started suggesting them as a referral code, do you want to go in for mediation? Many of them have said yes. So we could, in fact, refer 43 matters to mediation. So with this process went on in a period of 1 year, I got a fair idea that I should do it. And then luckily I came across with the very good mediators from the Hyderabad Mediation Center, Arbitration Center. They gave training to the judges of commercial courts also. Lawyers were trained. We have 11, found a batch of 11 lawyers. Then we established our MEDAP Center. So though there is a mediation center in the High Court, commercial disputes were being referred to the mediation center. But I felt with the establishment of arbitration MEDAP Center in the arbitration center premises made a difference. Gradually, with the passage of time, people started coming forward, lawyers came and said that please refer to my matter to mediation. So the backing for MEDAP Center is Section 30. Section 30 says, if during arbitral proceedings, I'm not quoting the subsection, sorry, it is not incompatible with the arbitration, no, sorry, Section 30. Yes, it is not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement of the dispute, and with the agreement of the parties, the arbitral tribunal may use mediation, conciliation, and other procedure at any time during the arbitral proceedings to encourage settlement. So this gave me that perspective that mediation center is to be there in arbitration, and we have to integrate mediation into arbitration. So while taking forward this perspective of why this mediation center, integrating mediation with arbitration is necessary for our state, for the state of Gujarat, I'll take you forward with some statistics. The first slide shows you the effort of institutional mediation, mediator or mediation be a catalyst to high velocity economy. So Gujarat is a high growth industry led state. It has a strong base in manufacturing. The second slide will show you how economic activities can be linked with litigation and mediation. So wherever there are disputes, as Mr. Janak Dwarika Das in his address yesterday has mentioned, that businesses need closure. Where would they go? If you're not providing them sufficient closure in a time-bound manner in the court, they have to go in for arbitration. You have no option but to strengthen arbitral institutions. So I'm taking it one step further, that if we are not able to deliver them on the judicial side, and even arbitration is also at a crossroad, we must think and do, and with lot of our conviction, we must also strengthen the mediation institutions within the arbitration center itself. So this economic activity actually, which shapes the volume and type and complexity of disputes also, that is the reason why we go forward with this arbitration concept, mediation concept into arbitration. So if you look at the structure of economy of Gujarat, so this manufacturing industries, they contribute to around, I think, 49.53%. You're that, am I right? 49.3% we are gross state value added, GSVA, at current price rate is from manufacturing industries. 34.7% is from services, and only 15.9% is from agricultural and allied activities. And if you look to the right side of this slide, to me it is right side, to you it must be left side. GSDP, that is gross state domestic product growth, has outpaced national average per capita income. It exceeds the all India figure. So this is the state of Gujarat. And if this is the state of Gujarat and this is our society, then we have to think as to whether we are able to deliver to our society or not. What my understanding of court system is that courts are there. See, nobody needs us. Had there been no conflict, had there been no dispute, we would be jobless. All the lawyers, all the judges, there was no need for us. People are coming to you because they are in conflict. People are coming to you because they are not able to solve their problem on their own. Mediation, panchayat, they were all there in our system for times, like many times ago, for years ago, I think decades or even in ancient times. But with the increase in the complexity of the society and with globalization, we reach at the situation that we need to strengthen our courts. So when we are talking about courts, court doesn't mean adjudicating court only. Courts means judicial system. So if this is the state of economy, then our judicial system has to be answerable to the society, whether we are able to deliver to you. If a businessman, money, he files a recovery suit, and I actually feel pain at sometimes. There's recovery suit of 2000. That was a simple civil suit converted in 2017 to a commercial suit, came to my court in 227 petition. At the stage of execution in 2025, he did not get that 3 lakhs rupees. For 3 lakhs rupees, matter came to my court. And then execution did not, the courts, that is reflection. Whatever way we have decided it, whatever, I did not get satisfaction of deciding that matter because I dismissed it on the first admission date. Because he has already lost what he was supposed to get in 2000, and when he came to the court in 2000, the money must be due around 95, 97 or even 91 or 10 years. He must have got the courage to come to the court after 10 years. Who comes to you at the first stroke? Court is the last resort. People don't come to you by pleasure. People don't come to you because they're happy to come to the courts. They are coming to you because they have no other option. So if they have no other option, and the only option which we are giving them is adjudication, then we are not actually strengthening the judicial system, justice system. Justice system includes both every institution. So as per my understanding as the head of the institution is that our effort should be to strengthen every justice delivery system, to set it in place, to take it forward, to strengthen it in a way that it is efficient, it is transparent, and integrity of the institution is up to the mark. So in this process, if you look to this sector or to dispute map, this is again saying the same thing, giving us a picture of that what quantum the manufacturing industries are delivering in Gujarat towards GSDP. Correct. So the kind of litigation which, if you see this sector to dispute map, this shows the kind of litigation which are coming to the court. So manufacturing, urban real estate, agriculture, finance and insurance, they are all commercial matters. Litigation volume and systemic strain I have already discussed with you before even showing this slide to you. I'm not conveying you this that we are not doing anything or our courts are not deciding cases. What I'm trying to convey is that we are not able to deliver sufficiently. So demand and supply. So we are not able to bridge that chain. We are not able to cater to the demand. So then comes this aspect of human angle in litigation. The satisfaction triangle. So when we look to this satisfaction triangle, it is a simple measure for negotiation and decision making is when setting up negotiation or decision making process, people have three independent needs, which you can see in this triangle. We have to carefully consider in order to achieve that these needs are met. So procedural needs are about the opportunity to have a fair go. When I say that fair go means in a time-bound process also. The opportunity to put forward own point of view. These are the procedural needs, how people perceive and talk about things. So if you're giving a person a fair go, he would definitely want to put forward his own point of view. Opportunity to both listen and to be listened to. He wants to listen you as well, but he wants that he should be listened to. Having confidence in the information, protocols and meetings. So when we are delivering as a court, we are lacking in all this because they are not directly coming to us. They do not get opportunity to speak. We do not permit anyone who is a party in person, who is represented by an advocate to speak in the courts. There are emotional needs also in the litigation. And these emotional needs are personal and emotional aspects people always bring to the negotiation table. When you are a mediator, you know that people are fighting for something else, but actually their needs are something else. How people feel about what is being negotiated for. We can't do this in litigation. We can give this confidence in negotiation, in the mediation, on the mediation table. How people feel about themselves during and after the process. So in the court, what you do is that you listen to both sides. What we do, what I do, is that I listen to both sides. Whatever my understanding, whatever my little understanding of law with the experience and with the assistance of lawyers is, I decide the cases. But I don't know whether I'm able to actually satisfy them, satisfy the procedural and emotional needs. Maybe I'm able to satisfy the procedural needs as well because they are coming through the lawyers. But I always think that I'm not able to satisfy, and that is not possible for any court, to satisfy the emotional needs of the parties. There are substantive needs like material things and issues people actually want to negotiate about. That is money, time, rights, possession, and some intangible aspects. They are respect, consideration, which you can't give in any litigation by any judgment. So what a judgment does? A judgment, do you think a judgment concludes litigation? We have appeal, revision, 227 Supreme Court, starting from civil judge to district judge to High Court in second appeal to Supreme Court, and then litigation concludes. So litigation concludes, judgment concludes litigation, but judgment does not conclude conflict. Even after a decree is passed, upheld by the Supreme Court, execution is another tardy process. So adversarial contest deepen mistrust and hostility. Formal outcomes may not preserve relationship, or even commercial continuity is not possible. Appeals, we know that the emotional fatigue, the emotional aspect is completely frustrated. We actually create a situation that the emotional angle of the litigation dies completely. They forget when they started litigating at the end of 10, 20, 30 years, they forget as to why they were fighting and why they started fighting. They are fighting because they have to fight. They are stuck in litigation. They are stuck in a judgment which does not understand them, which actually does not deliver to them. So they have no option but to go in appeal, but to go in Supreme Court, to seek a last closure to their idea of their dispute. So everyone has his own perspective, his own idea of the dispute. So this idea of dispute he is not able to convey you in a litigation. So this satisfaction triangle, that is how remained imbalanced. Here mediation comes to the rescue. Table is turned. Procedural satisfaction comes with the sense of procedural satisfaction. Emotional satisfaction comes because parties feel respected, they feel that they are heard, treated with dignity, and their anxieties, which is the most important aspect of litigation, which is addressed in mediation, and the grievances are at least acknowledged. At least mediator told them, okay, I understand why you feel so disturbed. I cannot relate with you, but then I can understand your I can at least try to understand your point of view. What you are putting to me, I am trying to understand it without even offending the party that you are wrong or what you are saying is not correct. This is actually substantive satisfaction. In the mediation process, both the parties, they come to the mediator initially fighting with lot of vehemence because they have not met for so many years with each other. They have not talked. They have not seen each other's faces. So when they come to the table and you do not know, as to amongst these two parties who is actually, whether both the parties are actually on a level playing field or not. The other party may be having control of the whole dispute. And when I'm saying dispute, it is not litigation. It is not case. Dispute is, when I'm saying dispute, dispute means human angle. So he is, the one party is taking the whole control of the dispute and the other party is trying to push to get some kind of like one opportunity to come to the table, to bring this party to the table. One is here, another is here. So this one is trying to somehow, I can push him down, and bring him to the table. So what mediator does? Mediator brings them to the table. And that is why in mediation center, there is a circular table. So even mediator, parties, their families, their lawyers, they are sitting at the same level and they are talking to each other. So this level playing field, which you cannot give any litigation, can be given in mediation. This level playing field, even if ultimately they are not able to come to a settlement, you never know. A mediator never knows whether the parties are going outside the mediation center and after some time they settle on their own. Because only thing what a mediator did is, only opportunity they got is that they came to a table. They started talking to each other. And if a mediator is able to do that, let one sentence, let one eye-to-eye contact, if they are able to make, even if no settlement, no immediate settlement arrives, I'm sure, and mediator must be sure that you send them with a message that whenever you feel like you can settle. So this substantive satisfaction, even if in both stages, in the final outcome and even if there is no outcome, that is nowhere except in mediation. And final outcome means final settlement. Final settlement, then no further dispute, no appeals, no revision, no Supreme Court. So while I say this, what I mean that is, at its core, mediation is about resolving conflict at a human level. It treats parties as people, not as cases. It draws on behavioral sciences, how people perceive fairness, offer and receive apologies, and move from anger to acceptance. The process allows space for emotions and narrative, while still working towards a structured, legally responsible settlement. So though parties are before you, they are in dispute. They don't want to see each other's faces. But once they arrive at the settlement, it becomes duty of the mediator to draw a settlement which is legally sustainable settlement, legally recognizable settlement. So this blend of law and human behavior makes mediation particularly suited to dispute involving families, neighborhoods, long-term business partners, and communities. So whole idea of conflict resolution in mediation is, according to me, is human angle, behavioral science. And that is why when we were trained, we were told that mediation is a science and an art. Now, why institutional mediation is necessary? Institutional mediation is needed because it actually reassures parties that you are at the right place. You are with the right people. You will be heard here. And if you are disclosing anything in confidentiality, your information will not be misused. So when we are talking about institutional mediation, we are talking about institutional mediation being conducted by neutral mediators with institutional oversight, administered by recognized centers under clear procedural rules and settlements which are documented and legally enforceable. We have initially I've started with this only, that we have no option but to strengthen our institutions. We have no option but to give each kind of, but to strengthen each institution. Courts, arbitration is arbitral institutions, and mediation. Mediations are of two kinds, like mediation other than commercial. We have segregated it, looking to our society, looking to the needs of our society. Otherwise, mediation is one, technique is one. But like in our MEDAP center, when the lawyers, mediators who are well versed in commercial matters, who have deep legal knowledge of commercial matters, they do mediation, and they are living in the same society. So they have a fair understanding of society as well. So when they do mediation, the parties' confidence go to another level. They know that there is one person who is legally sound, who is trained person in law, but still he is not diverting me to court only, where I will be at the mercy of the judge. Rather, he is taking us to mediators. He's taking us to a solution with his deliberations and understanding me. So it's a legally grounded resolution process, combines enforceability with flexibility. Institutional panels ensure neutrality and quality control, strengthens rather weakens the authority of courts. So if we are able to settle, if we are able to, like I as a judge, always find satisfaction in deciding cases when they come with the mediation settlement. I don't find that satisfaction in writing judgment, I must say. This because being mediator, by core, by heart, I am a mediator. Then I'm trained as a lawyer, then I'm trained as a judge over the period of 12 years. But the satisfaction you get in deciding the matters when mediation settlement has arrived cannot give you satisfaction of giving a judgment, though we have to give a judgment on legal points. But in those family matters where people are fighting with partition suits, with partnerships, they have started partnership not to fight. They have started partnership to continue, to start a venture, to go ahead, to earn, to give money to their family, to live to a status to which they want to live, to own a car, to own a house. For them, it matters. They need it. They needed it, and that is why they entered into the partnership. So if we are giving them justice, so-called, by delivering orders after 10 or 15 years, at least we have taken his chance to own that car, to own that house. which he could have owned 10 years ago. So this institutional mediation in commercial matters can be integrated according to me, and I say this with lot of conviction, because in commercial matters, what I thought of, what my understanding is, that there is always, almost always, a human angle involved in a dispute. If you find out that human angle, I think you will find out the solution. So that I'm not saying that one size will fit all, but then in courts also, all the cases are not fit for settlement in mediation. Similarly, all commercial matters are not fit for settlement in mediation. But there are matters which can be identified. There are matters which can be identified not only by the courts, but by the arbitrators who are sitting here. So my appeal is to all the arbitrators that once dispute goes to you, even after reference, and you, after the statement of claim is filed, you can correct me. You can look to that angle. You can actually look to that angle, and if you find that there is any semblance of settlement in the matter, then please don't go ahead. Help the parties, not press them, not force them. Help them to realize that this is also possible. Help them to realize that yes, you can save your time, you can save your money, you can save your energy and go in for settlement. If you do it, I would say, like, I can say with all humility at my command, that you will be respected more than you are respected as an arbitrator. Your strength being a fair arbitrator will be actually more. People will have faith in you. People will go to the court and tell, please appoint so and so as my arbitrator. People will go directly to you and say, please decide my case as an arbitrator. I'm submitting to you, but they know that you will taking them to the right direction. So this is what I consider as the magic of mediation, which can be integrated everywhere, which can be integrated not only in the courts, but it can be integrated very well and very authoritatively, very impartially with the integral process, institutionalization of mediation. Integrating mediation into arbitration is actually it is not only possible, it is actually the need of the hour. We have to adopt to this. We have no option but to adopt to this. Otherwise, one day people will reject us. People will even reject arbitrators. They will say that you are not good for me. They have faith still in courts. They still have faith in arbitration process. That is why they are coming to the court. I have mostly in section 11 matter, I have a board of 100 matters on every Friday. That shows that people are having faith in arbitration as well. Then comes the role of lawyers. When I'm saying I'm mentioning lawyers who actually have filed cases, who have filed applications for under section 11, who have filed appeal under section 37, who have filed suit under section under Commercial Court Act, who have filed appeal before the High Court or the District Court under section 13 of the Commercial Courts Act. I think you can be the person who can take this mediation movement ahead. See, why this is necessary? Because parties come to the court through you. They trust you. They don't trust us, the judges. They don't come to us directly. They come to you. They go to you because they know and they have this faith and belief that you will prepare their cases, you will understand them, you will understand their problem, you will understand their conflict, and you will also understand why they need to file this case before the court. And you will present the court in a way that all points are taken care of, all legal issues are properly taken care of, my matter is well drafted, and it is put up to the court and arguments are made in a way that I'm going to win. No party comes to the court to lose. Everyone wants to win. And why not? If I'm in a dispute with anyone, actually in a dispute or conflict, I would like to win because I'm a human. So every human who is in a conflict needs not only solution but win. Jeetna hai. So this spirit to win, they put before the court through the lawyers. You are their spirit, you are their faith, you are their trust, which they put in the courts. So if you use that faith, that trust, that spirit to direct them, or I may say that redirect them to mediation. I don't consider that they will say no. Everyone will not listen you. Everyone will not agree with you. But we don't work for that. You don't prepare your cases and argue your cases as a lawyer because you know that you are going to win your case. You present your case, you present your arguments before the court because you want to put up your best. And your best means the party's best to whom you are representing. So, but when the party itself, like any party who is in conflict, you put up this in an appropriate case as a lawyer. I understand that with a good experience in a particular field, having domain knowledge, legal acumen, you understand where the dispute lies. You understand and mostly many of the parties, they confide to their lawyers. They know that you are not going to divulge this information to the other side. That is the trust they have in you. So that information divulged to you during the course of deliberations before preparation of the case, or even after preparation of the case, and even after putting up it in the court, you can always use that angle, human angle, to the problem, to guide the party, not divert them, to guide the parties that this is possible, their solution is possible in mediation. And many a times as a court also, while dealing with the matter, when I suggest to any lawyers, is it possible to settle the matter? So I request the lawyers every time, please use your good office to guide them. So that is the bridge which that is the bridge, which bridge is actually you are in this human conflict. So again, I come back to why there is a need for institutional mediation. I need not to say that this is cost-effective resolution. I think I've spoken enough in integrating mediation into the justice system already before showing this slide to you. So this is what I needed to emphasize. Institutionalized mediation can become a dependable arm of justice system. This is our goal should be. And this is my dream. So let us talk about what you mean if I go by literal meaning of why we call these two. Okay, I'm little bit diverted. Section 89. Section 89 CPC recognizes. I think a question was put in the previous session about bringing family court matters, but that I'll answer it later. But if we read section 89, because whenever I'm referring to a section, I'm in the habit of reading from the book. Because as a lawyer, we are trained that you have to read every time. Whenever you are reading into a section, you are even thinking about the section, please read from the book. Don't imagine, because every time you may miss something. If you're reading it every time, you'll get something out of it. So if I read section 89, it says where it appears to the court that there exists element of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations of the parties, the court may formulate the terms of a possible settlement and refer the same for. So this first part of subsection 1 of section 89 is a little bit diluted in a way that we don't in fact formulate the terms of settlement, don't give it to the parties, and in fact we use the lawyers as a bridge for this stage. Then the first part is arbitration. It says, subsection 2 says, refer to the same where a dispute has been referred for arbitration, and it says where a dispute has been referred for arbitration or conciliation. The provisions of Arbitration and Conciliation Act shall apply as if the proceedings for arbitration or conciliation were referred for settlement under the provisions of that act. So section 11 almost take care of this, of the Arbitration Act. So it is referred that way. Then comes judicial settlement, we do not need that. Then clause D of subsection 1 of section 89 says mediation. So when section 89 refers to mediation, it says for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. So this is what the CPC by the Act of 46 of 1999 had conceived. And this section was the basis for setting up those mediation centers in all court premises now almost throughout the country. So this section 89 talks of mediation and settlement in different clauses of the same subsection, but the spirit is one and the same. Then if the court finds that a matter is fit for settlement, or if the court can motivate the parties to a settlement, the court should do it. So this is the mandate of section 89, and that is how we established our ADR institutions. ADR institutions is an umbrella for arbitration and mediation both. So we call what we call in, like what we refer to in an ADR institution is dispute resolution. We call them methods of dispute resolution. We don't call adjudication. Why resolution? So what I understood from the literal meaning of resolution is it is an act or process of resolving. The act of analyzing a complex notion into simpler one. The act of finding an answer or solution to a conflict. It uses the word solution. And then a method or action taken to solve a problem. Again, solve, which results into a final settlement of a conflict. So solution, solve, final settlement of a conflict, solution to a conflict. So to such extent that outcome of process is conceived on the final solution or a firm decision, which cannot be challenged further, which is not prone to challenge. Parties will not have a second thought about it. After a decree is pronounced on mediation settlement or an arbitral award is pronounced and signed and delivered to the parties on a mediation settlement. So I would like to conclude again, reiterating at the cost of repetition that we have to resolve, we have to have a firm resolve that all methods of adjudication I will not use and resolution of disputes should be strengthened if we actually want to deliver the society. If we actually want to remain relevant, if we actually want that people should come to us, people should see us as their problem solver, not a problem creator. I've already referred that one size cannot fit all. We have to have we have to be very, very cautious while referring the dispute to mediation. We should also be cautious about as to it may not happen that parties are asking you to send the matter to mediation only for the sake of buying time. They actually mean it. And you actually found after all efforts made as a referral court, and now I would refer as a referral arbitrator as well, that to identify that this is the dispute, this is the matter which is fit for mediation. So while referring to integrating mediation with the arbitration, I have gone through actually my Gargi and Jay have helped me in getting all these details, and even my legal assistant, they have brought me before me that this model has already been adopted in Singapore. Singapore International Mediation Center and Singapore International Arbitration Center, they have collaborated to create a protocol of ARB-MED-ARB protocol, which they call is ARB-MED-ARB protocol. And it very succinctly and very clearly provides the procedure, and even the parties have to fill up a kind of undertaking form that they want to go in for mediation. and it discusses how it works. So far as our arbitration center is concerned, when I came across this Singapore protocol, Singapore International Arbitration Center's protocol, then I have gone through the rules. Initially, I was thinking of that we have to frame rules. I was told initially when we established Mediation MEDAP Center that we have rules. But while preparing this, I forgot. So then I again looked to the rule. And then I found that in our center's rule, which was framed in 2021, the vision was already there. The rules Arbitration Center, Domestic and International High Court of Gujarat Rules 2021, in Rule 21 provide for reference to MEDAP. Though heading is only MEDAP, but these rules are both for MEDAP and ARB-MED stage as well. So I would like to read these rules, if I'm not considered to be boring now. So Rule 41 says the reference to MEDAP. 41.5 says confirming parties to an arbitration agreement may at any time before the commencement of the arbitration proceedings or while the arbitration proceedings are in progress opt for mediation and request the arbitral tribunal or the director, as the case may be, to put the arbitration proceedings on hold to enable the parties to resolve their disputes amicably. 41.2 says the parties should convey their request to the arbitral tribunal, or if the arbitral tribunal is not in session, to the director or to the director before appointment of arbitral tribunal. Then it further says, 41.3 says, the arbitral tribunal shall accept, it uses the word shall, accept the request of the parties and keep in abeyance the arbitration proceedings, relegating the parties to MEDAP. 41.4 says, if the parties settle the dispute through mediation, the settlement agreement executed between the parties shall be forwarded to the arbitral tribunal, which shall, on receipt of the settlement agreement, after taking into consideration objections, if any, and further taking into consideration executability of the settlement, makes an award on the basis of resultant settlement terms. So you can refer, it will come back to you, you will analyze it as to whether there are any objections to the settlement, and if so, then take into consideration also whether the agreement is executable. And every mediator is taught to write an agreement in a way that it is executable. It ends the dispute finally. There is no future clause for which the parties have to go to the court again. 41.5 says, before appointment of the arbitral tribunal, the 41.4 is about ARB-MED. Actually, it says MEDA, but it is actually ARB-MED. Before appointment of the arbitral tribunal, if the parties settle the dispute through mediation, the settlement agreement executed between the parties shall be forwarded to the director, which shall, again word is shall, on receipt of the settlement agreement, makes an award on the basis of the resultant settlement terms. So it is if they come directly to the center. Then 41.6 gives a closure that such awards as pass to record settlement between the parties should contain an express statement on its face, and that it is an award made at the parties' joint request and with their consent. So if you write it that in the award, that the award is made at the parties' joint request and with their consent. So they cannot challenge the awards on any other ground other than imputing malafide to arbitrator. Misconduct on the part of the arbitrator. And that is very, 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 very rare, extremely, exceptionally rare. So our arbitration center, when it was established in 2021, it has the vision of arbitration, not only arbitration, but mediation and arbitration, arbitration and mediation, arbitration, mediation, and again arbitration. So this vision, which was in the rule book in 2021, we have started as a baby step. We have started in 2021. And now with this new logo, we want to set it at place. We want to emphasize it. We actually want to show that we are serious about it. We are not only talking, we are doing it, and we are strengthening it. We are going to do it. So this logo, we have long deliberations on this logo as well, whether we are actually integrating mediation in arbitration. Mediation in arbitration, and whether we should do it with lot of conviction. So this logo represents the dream of Gujarat High Court Arbitration Center. It is actually the dream. Dream of the center to establish it, to showcase. Today we are showcasing, tomorrow we are going to do it. That we are a center where actually mediation into arbitration is taken as a serious venture. I think every Gujarati understands the meaning of venture. What you call in Gujarati is, can you add to it? Huh? Please, please. Please, please. Speak on the mic. I understand Gujarati. I can read it, but I cannot express in Gujarati.
It's called sahas to an extent, sir.
Sahas.
Sahas.
Sahas. Sahas means?
It's a courage that you take. Shurwa.
So this is our sahas. See, I'm not a Gujarati, but I'm basically a Bania. So there's not much difference between a Gujarati and a Bania. And I must, I may tell you that I am also brought up in a business class family. So my father's side, my father was a lawyer, but my father's side mostly. So somehow that business is in root. It is in blood. So this Sahas venture, this Sahas is this logo. So I would like to ask you and seek your assistance, seek your support from this place, whether you are with me to take it forward. So say yes in loud voice, I must listen in. So this is why this session was, I wanted to do this session. I wanted to convey you, I really mean it. See, Gujarat is one place in 2 years, more than 2 years, not 2 1/2 years exactly, that way 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 2 1/2 years exac you're actually I must not, like, I may not be mistaken, I may be wrong also. I think 70 to 80% of the litigation, arbitration litigation emanate from Gujarat. 70 to 80% must be, because there are so many companies. When I came here, I realized that all manufacturing units are in Gujarat. I have never pondered about Yera glasses, which I was using for so many years. When I came here, I realized, oh, acha, this industry is also in Gujarat. Watches, Ajanta watches. They are part of our daily life. Like since early teens, I have seen them, but I never knew, like I never bothered about. I may have known it, but I never bothered. So when you have this much of potential, so why don't exploit it? Why not lawyers of this court get this kind of recognition all over India, that lawyers of Gujarat High Court are well versed not only in litigation, but in mediation and arbitration as well. Gujarat High Court is not #1 High Court only in court litigation, but it should be #1 in arbitration as well. High Court, why? Again, we are talking about venture, sahas. So हमारे साहस को तो nobody can stop. Nobody can stop us from venturing and being Gujarati. Who else know better than what is the result of venture? If you don't step out of your house and you don't take risk, you don't start anything, how will you get the results? So I want to conclude with only few words, that only what we need at this moment, when I said that I am at a crossroad. So when I said that I am at a crossroads, doesn't mean I as a person. Actually, that time I said with that point of view, but actually I meant it that I am a crossroad as the head of the institution. Whether actually, there is a need for a change in the mindset. It's only mindset which takes you, it's your mindset actually, which actually leads to your decisions. We all have perceptions with the passage of time, with our experience, with our education, with our surroundings, with our upbringing. We have gradually, we have developed a mindset, and we work in that mindset. So whatever mindset we bring into our work, the kind of results we get, it's very directly connected to each other. So my appeal to you is that there's a need for a for a change in the mindset in thinking about the future of arbitration. And we have to ask, all arbitrators must ask themselves, that do we really need on all occasions to give parties an award? A resolution of the dispute, which though voluntary, focused on party autonomy throughout, but in arbitration, they lose their control. It does not remain voluntary, impractical. In an appropriate case, we have to question ourselves whether in an appropriate case where the parties are seeking only closure, whether we still want to give them award another level of challenge or just adjudicating their disputes, not resolving, or whether we need to send them home with a settlement. A win-win situation where the satisfaction triangle in a dispute is meted, it is satisfied, where the closure brings satisfaction. Can we think of making arbitration a service in Gujarat High Court Arbitration Center? Thank you so much.
Thank you, Your Ladyship, for a very enthusiastic and insightful session. We are truly honored to stand here and offer a heartfelt gratitude for sharing such powerful insights on mediation. Your words remind us that mediation is not simply a process, it is a mindset. It is about listening with intention, speaking with care, and choosing understanding over conflict. In a world where disagreements can so quickly divide us, your message brought us back to something essential, the human connection at the center of every dispute. Thank you, Your Ladyship.
So you can call me.
Yeah. So now, for the next session, I'm sorry.
No, in continuation of this.
In continuation of this session, we welcome the advocate mediators of the Med-Arb Center of Gujarat High Court to share their experiences and engage with the lordships. We invite on stage Mr. Amar Bhatt, Mr. Asfi Kapadia, Mr. Pitambar Abhichandani, Mr. Hriday Buch, Mr. Dhaval Vyas, Mr. Tarag Damani, Mr. Nishant Lalakia, Mr. Nikund Rawal, Mr. Manan Bhatt, Mr. Radhesh Vyas, and Mr. Archit Jani.
Founder batch of Med-Arb Center. I think they need us from you. See, I must tell you that they are working pro bono for I think more than 1.5 years, almost 2 years. Almost 2 years they are working pro bono. And whenever I mention that I'll see that whether I can give you fee, they say, no, we don't need it. And I know that they don't need it, actually. But what I'm trying to say is that being a founder batch, like I was also a part of founder batch of Mediation Center in Allahabad High Court. So I can understand their anxiety also. I can relate to them very well. Because when the concept of mediation is introduced to you for the first time, like in first training, I was so totally lost. I could not understand what mediation is all about during training. Though I understood the basics, but then doing mediation and actually understanding mediation needs practice. So you are given a training, then you are like that mediation, you are given the charge of center and you are thrown open and nobody is there to guide you. You have to evolve your own ideas, you have to evolve with each and every problem is unique, which each and every party is unique, each and every person is unique. So there are sometimes mediators also face anxieties. Correct? Am I correct? See, mediators also face desperation. Correct? When I started working as a mediator, so for 1 year, not a single matter was settled. Whatever I mediated, not a single matter. So in mediation center, I was known whatever was sent to you, it is not going to be settled. But then you cannot sit down. You have to go on. So I continued. And the first matter which I could settle was on a Dhanteras day. So that was my treat. I left mediation center around 8:30 p.m. and I was so happy कि Lakshmi ji आज मिल गई मुझे. So I requested them to participate in this session because I was feeling a lot of anxiety being all alone in the session. So I requested them, and actually I want them to relate to you. I want you to relate to them, and I want them to motivate you to take up this task. So over to you. So they are going to to convey their experience also and whatever they think about mediation.
On behalf of the team of 11, we are a team of 11, and today is an important
That
match.
number was chosen purposely because when you start something with a shagun ka lifafa, so like in olden abhi to now to shagun ka lifafa is not less than 501. But we started as misers, we were misers, so we started as with 11 number. Shubh, shagun.
So first of all, congratulations for conceiving the state-of-the-art building. Yesterday we saw that there are 16 rooms for arbitration and 7 for mediation. I'm sure that with the efforts of everyone, the number of rooms for mediation will be more than number of rooms for arbitration. My compliments for organizing this conference. All sessions, including lunches, have been carefully crafted. And I thank your ladyship for comforting us that we are not sitting in your ladyship's court today.
Yes.
The important thing that Madam talked about was that it is not just for the sake of talking that we are talking about mediation. I was reminded of a sher by poet Dushyant Kumar. His poems were very famous during emergency time. And that is very apt for this, everything that is being done for this. सिर्फ हंगामा खड़ा करना मेरा मकसद नहीं, मेरी कोशिश है कि ये सूरत बदलनी चाहिए. तेरे सीने में नहीं तो मेरे सीने में सही, हो कहीं भी आग लेकिन आग जलनी चाहिए. So we are trying our best mediation because it gives a complete resolution. There is no further appeals. Nothing remains at the litigation level. And I was
Okay. Mic is not working.
We are pleased to welcome Honorable Mr. Justice N.V. Anjaria, Judge Supreme Court, to join us on the stage.
Jagah rehni chahiye. जगह छोड़िए ना, वो निकलेंगे. वेलकम.
so
they are the mediators. I have completed. They are sharing their.
Dushyant. I was just talking about a poem by Dushyant Kumar. which is very relevant because the efforts that are being put in. That सिर्फ हंगामा खड़ा करना मेरा मकसद नहीं, मेरी कोशिश है कि ये सूरत बदलनी चाहिए. तेरे सीने में नहीं तो मेरे सीने में सही हो कहीं भी आग, लेकिन आग जलनी चाहिए. Madam also said, and that is the experience of all our mediators, that initially nothing gets settled, but we have to keep on trying. And again, pardon me for my love for poems. Mariz Sahib of our Gujarati poem has said that Radha koi male na male bhale, e apni faraj che venu vagadiye. So we are trying to do that. We have to keep on trying, and this arbitration center is in a way giving birth to the concept of Professor Frank Sender, multi-door courthouses. In 1976, in Roscoe Pound Conference, he gave this concept of multi-door courthouses, where there would be a gatekeeper, but the gatekeeper would be sending the litigant to appropriate dispute resolution system. There was neutral evaluation, there was mediation, there was arbitration, and then finally court. So this MEDAB center is really conceptualizing the concept of Professor Frank Sender. And in 2017, when there was a global Roscoe Pound conference at Chandigarh, there was an interesting statistic that 70% lawyers think that they are hired only to argue. 80% litigants want their lawyers to give quick resolution at an affordable price. And lawyers think that mediators are settlement junkies. So in this conflict of perspectives, we have to look beyond that, and that is what we are trying. This session, while we are at the end of the session, it will be, I mean, everyone will be saying something. So anything, Pitambar.
Good afternoon, everyone.
You have to bring closer.
In the journey of being a lawyer and a mediator, and now an arbitrator also, the center which is integrating the process is trying to utilize the infrastructure which is existing. We have a wonderful plan that is being set in place. So hopefully the system will have fresher and more blood getting into it, more number of mediators being trained. One of the experiences that I can recollect and share, maintaining the confidentiality which is required in a process of mediation.
You are live.
Yes.
There is no confidentiality.
So I will be very careful, ma'am. Thank you. Yes. It is more of a commercial dispute which was referred by the Honorable Court to the Arbitration Center in the MEDAB Center, wherein one of the parties was a corporate entity, another one was a private individual. And during the course of the caucus sessions, we could try and get the questions were rephrased, reframed, some further details were sought for. And one of the things that could eventually be unearthed was that one of the parties' relative was having a medical crisis requiring a quick resolution. The other party was in a very truncated, structured manner conveyed with the permission of the other party, and things got resolved. Such experiences inspire me to say that yes, if the human approach is integrated, the humane approach, it does help the parties to resolve the solution, come to a solution.
You told that he wanted to be with his wife.
Yes, in fact, I was not divulging a lot of details which your lordship said.
That's much you can say. Now they have settled.
Yes, they are in a very proper space now, and a complete resolution to all their disputes which were there. Thank you so much.
As the Honorable Chief Justice has said, mediation is a necessity now. It is imperative because, as Janak Dwarkadas yesterday said, the courts are clogged absolutely, so that to get the relief through the judicial redressal system of courts is very difficult. You have layers of appeal and years go by. Earlier we had an alternative dispute resolution system in the way of arbitration. Arbitration, fortunately now with the amendments, we have a time-bound schedule of disposing arbitrations, and arbitrations are disposed comparatively expeditiously, let's say in a year and a half, two, and that is also good enough. But the main problems start when you have section 34 and 37 and right up to the Supreme Court. And then again you are at the mercy of the courts. And when I say mercy of the courts, and as Janak Dwarkadas says, you can't blame the judges. The courts in India at every level, the civil courts, the high courts everywhere, and even the Supreme Court, they are burdened with so many matters. It's not human to expect them to expeditiously decide matters. And of course, when they have to decide correctly. They have to devote time as much as is required in a particular case. So therefore, the alternative of mediation is the only alternative today. And even in cases of arbitration, this concept of mediation arbitration, which is known as ARB-MEDAB, is a very good initiative, because even in arbitration, people have still hope. But if it can be resolved through mediation, nothing like it. Because there the parties decide their own fate, they agree to it, and they agree to it happily. So at the end of it, if a settlement is arrived at, both the parties go home satisfied, at least, and at least with the satisfaction that they have agreed to it. They have had their say. Of course, mediation, as everybody has experienced, is a little difficult sometimes. People's mindset in India at least have yet not opened up and changed to that extent which is required. But I'm confident that with passage of time it will happen, and more people will repose more faith in mediation, and mediation should be the guiding force in future. That's my view. Thank you, everybody.
Good afternoon. I will straight come to my experience. Immediately after the training was over last year, one of the mediation was referred to me. It was a Section 11 application, and Honorable Chief Justice asked the parties that why don't you settle? And accordingly, they had agreed, and mediation was referred, and I was the mediator. The dispute was between a reputed hospital and a cardiothoracic surgeon attached and affiliated with the hospital. And the dispute between them was with regard to sharing of the profit. And the doctor had initiated the proceedings, and he was the petitioner. Eventually, they were at the loggerheads. So in the first meeting, I just made them smile at each other. The hospital was represented by one of its founders. And then during the course of discussions, I could make out that the principal issue is with the issue of sharing the profit was on only one component which was disputed, and that component was that equipment and medicines which the hospital charged from its patients was on MRP, whereas the actual procurement cost was less. The doctor was wanting profit from the remaining portion which the hospital actually saved. Ultimately, in the second meeting, while the parties were dispersing for coming out with a better resolution, I just sensitized them that how will you, suppose if the dispute goes further and if you don't settle it today, how will both of you come to or go to the mediator or the courts and prove your case? That what are you claiming and why are you denying? Eventually that sensitized them, and ultimately the dispute got settled. Fortunately, it was the first mediation which was settled in the center, and I was very happy to, and that continued. And I would, taking cue from Amarbai, I would just end with one stanza of one Gujarati poem, which is by one Naishad Parmar. he says કે સૌને રૂચે એવું વિધાન હોવું ઘટે. So there has to be an enactment which is suited to one and all, and that is the mediation is, I think, the best suited resolution.
I would also just like to add the role of arbitrators, because I think the arbitrators should also play a proactive role and try to identify which matters can go to mediation where there is an element of settlement. And during arbitrations also, they should encourage parties to settle either between themselves or refer it to the mediation center. I would just give an example. I was involved in an arbitration with respect to a foreign company for oil and gas exploration. And it was a three Supreme Court panel arbitration where one of the members was Justice Shri, who was our honorable guest yesterday. And the initiative came from the tribunal itself. They encouraged the parties for a settlement, and the parties ultimately settled. So what I'm saying is that the arbitrator's role is also, because a lot of matters are into arbitration, and they should also take a proactive role and not just try and finish off the matter by an award. But if it's possible to settle the matter, they should encourage the parties for a settlement. Thank you.
Good afternoon, everyone. From whatever little experience that I got from the mediation, one thing that I have understood is that we as lawyers really lack that we don't want to go for mediation. We don't encourage clients to go for mediation. So it's one of my humble requests to every one of you as lawyers who are practicing on this side, that we should promote mediation. We should impress upon the clients that they should go for mediation, because there are a lot of things which happens in mediation. The issues can be settled, and both the parties, most of the cases, one case that I and Mr. Lalakia have jointly been able to resolve. In that, originally when the parties came, it was impossible that it could have been resolved. But later on, with 5 or 6 sittings that we had, finally we were in a position to settle the issue. Both the clients were happy at the end of the day. So if you're in a position to settle, I think as lawyers, we should try to promote this thing. And this is one of the quickest resolution that we can get. Thank you.
Good afternoon. All of us, 11, the first batch, we've been the part of the initial growing of the center, and perhaps with the efforts of the Honorable the Chief Justice and the Board of Governors, we all have understood one factor, that the center is no longer just a venue, but now the efforts are made to have it a cultural building institution. And that is how we've seen the growth of the center at our end. Thank you.
I'll share my experience as a lawyer who is doing mediation advocacy. I've had experience with Tarak Bhai, yes, of course, but the senior mediator was there in a matter which was referred by my lords from an latest patent appeal, which involved a public body, a corporate, is a statutory body. Now, for a statutory body to be involved and to say yes to a mediation was quite a task, but it took quite a lot of efforts as an advocate to convince the government that it is in the interest of the parties to settle. When you evaluate as a lawyer with the client and the clients are convinced, then you become a bridge for, so as to resolve this. So my experience, thankfully, because of the mediator also, so the senior mediator was Mr. Pitambara Abhichandani, that it could be resolved within 2 sittings. But a lot of efforts went in explaining the client why they should enter into mediation. Once they are in, and when they can come up with these answers, it goes really well for them. Thank you.
My sharing of an experience is more like a confession. When I started practice as a lawyer, a litigator,
Closer to the mouth.
When I started practice as a lawyer, litigator, I thought winning is a justice. Arguing.
Bring it more close. Closer to the mic.
Winning a case is a justice. That's what I used to believe. Arguing at the top of my voice, finding precedents and telling tendering the court that's better squarely covered, and the matters was getting the favorable orders, I used to consider that to be a winning, and winning was like was considered to be a justice. But thereafter, I went under the mediation training, and I realized that in most of the disputes, the law is not at the center of the dispute, but it's rather an ego. What we are seeing is the tip of an iceberg, but beneath the iceberg, there lies emotions, greed, opportunities, revenge taking attitudes of the parties, overconfidence, communication gaps, knee-jerk responses, and saving the faces. In short, it's ego rocks. So whenever ego rocks, justice goes. So I personally believe that the transformation, the mediation training has rather transformed me also. Because earlier I used to listen to respond. Now I listen to understand and realize that the strongest person in the room is not the one who argues the best, but rather the person who listens the deepest and does not reacts and provides the solution.
So I think all of us here, we have been associated with law in some form or the other for different spans of our life. So we all understand what mediation is. But what my personal experience shows me is that it is still a relatively unknown concept in the general public at large. I wanted to share a very unique experience that I had in one of the first mediations that was allotted to me. This was a family dispute disguised as a commercial dispute. It was within family members. A father had left a very successful business to his children, and there was a bit of a problem there between the siblings inter se. They were all based outside India, so of course the mediation was to take place over VC. And one of the first requests that was made was that our mother would like to participate, the widow of the original founder. Now, this is where the ignorance part comes in. The 83, 84-year-old lady, barely able to see, barely able to hear, she comes on the screen as soon as the screen starts. And she tells me that, sir, aap chalu kare, uske pehle mujhe kuch batana hai. I said, please go ahead. I was hoping she'd have some words of advice for her family members. And she starts by saying that, sir, I have done art of living training. I listen to Sadhguru. I do this, I do that. I said, madam, very good for you, but why are you telling me all this? बोले नहीं सर, आप मेडिटेशन कराने वाले हैं ना, तो उसके पहले मुझे लगा कि मैं आपको बता दूं. So, of course, that was the level at which the discourse started. But by the end of it, she turned out to be pivotal. And once she understood, she realized, she said, बहुत अच्छी बात है sir, at least I'll be able to see the outcome. I'll see my family at peace if this works out. And it'll save us a lot of time in litigation, of course. So she was very pivotal. And the end result, the success that occurred was because of a joint family lunch that we were able to plead, beg, cajole, and well, mediate out of them. And once that happened, I think once everybody was on the same table, literally, they were also on the same table legally. And that is how we ended up being successful in a 20 or 22-year-old dispute. But that is the level of ignorance that we deal with. I think over to you. Thank you so much.
Good afternoon. So I just would like to share the two key takeaways for me in this mediation process, that it is a restorative justice. Restorative in a sense that it restores back the dignity, it restores back the relationship, communication, and it is a participatory in nature in a way that the parties own the dispute, the parties own the solution. We are just a facilitator and the conducive environment which we can create, just like my lady has created for us, all the mediators. Thank you for that.
Good afternoon. So in any commercial contract, mediation clause would precede the arbitration clause. So the intention of the parties is first to mediate and then to arbitrate. but there was no any institutional framework which provided both mediation and arbitration under one roof. And I think that is what the MedApp Center is trying to address that issue. In one experience which I had as mediator, there was a dispute which was referred, the commercial dispute. There was a contractor who was blacklisted, and there were claim and counterclaims. During the mediation sessions, the corporation, which was public sector undertaking, they agreed to revoke the order of blacklisting. And on the contractor was also ready and willing to forego part of its claim. So part of the claim was settled during the mediation, and the remaining was further referred to the arbitration. So that is how this hybrid model of MedApp really helped those parties.
So you put up a very valid point about this contractual clauses. So I think, yes, I missed that, and you added it very well, that in every contract, the arbitration clause contains, the first clause is that the party will try to settle their dispute. There would be a settlement talk, and only then they will invoke arbitration clause. So this is and then we are talking about party autonomy. Like whole Arbitration Act is based on party autonomy. So if parties want to settle their dispute, so who are we to give them award? So I think this is how, thank you so much for sharing your experience. And before concluding this session, I would welcome Justice Anjaria. Thank you, Justice Anjaria, for joining us. I would thank Justice S.J. Wazirdar for being with us. The panelist of the first session, I would thank Dr. Biren Saraf for being with us, for encouraging me to take this session forward. I am thankful to all my brother and sister judges for giving me perspective to speak in this session. I am thankful to all of you, all lawyers who are appearing in my court. You give me perspective every day to do my best. Thank you so much.
We thank the mediators for sharing their experience with us, and I'm sure this has inspired many of us to undergo the mediation training. We have with us Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India. He needs no introduction to this court. He started his practice in the Gujarat High Court by joining the chamber of late Shri S.N. Shelath, Senior Advocate. His Lordship was a standing counsel for the High Court and subordinate courts. He was awarded the Research Fellowship in 1992 by late Shri Naveen Chandra Desai Foundation, Ahmedabad, on freedom of speech and expression. He has rendered service as an Honorable Associate Editor, Gujarat Law Herald, but most importantly, he has been a trained mediator in the High Court Mediation Center. His Lordship was elevated as Judge, High Court of Gujarat in 2011, from where His Lordship took oath as a Chief Justice of High Court of Karnataka on 25/2/2024 and was later elevated as a Judge, the Supreme Court of India, on 30th May 2025. The last time His Lordship was here on the Arbitration Law Conference in the Gujarat High Court on September 20, 2025, he had expressed conciliation and mediation within the arbitration process should be encouraged, and it might help in speedy outcomes of resolution. Taking a clue from his speech, Gujarat High Court, in coordination with MCPC, has also conducted mediation training program for lawyers, where more than 50 lawyers this year have took training as a mediation training. Lordship will look forward to a valedictory address from your Lordship, and we promise that in the next conference to come, we will follow your roadmap, which you will show today. May I invite Honorable Mr. Justice N.V. Anjaria to give the valedictory address.
Chief Justice Sunita Agarwal, Justice Alpesh Kokje, probably in absentia. Oh. Justice Supaya, other sister and brother judges of this High Court. Justice Sikri in absentia, who's the expert panel. Justice Wazif Dar, former Chief Justice of Punjab and Haryana High Court. Sonia Ben Gokani, former Chief Justice of Gujarat. Dr. Sharaf, then the former judges of this High Court, without following protocol from this side. Biren, my good friend, Justice Sarin, Justice Tolaria, Justice Joshi, Justice Karia, Justice Mayani, Justice Patel. No, two are left out. Justice Kamal Mehta and Justice Pooch. So now again you have to clap your learned Advocate General Mr. Kamal Trivedi. Hansaben, I'm sorry, Hansaben Yatin Bhai Oza. Registrar General, other staff of the High Court, senior advocates, and all the lawyer friends. From Friday evening to Saturday morning, there were marriage functions. Today it is a family get together. So I'm more relaxed. Everyone is more relaxed. More particularly Sunita Ben. I believe that I should start this speech on the valedictory occasion by congratulating the Chief Justice and his team, the able team, for organizing this two-day conference on a very relevant theme, institutional arbitration at a crossroads, challenges and the way forward. And this conference has an occasional importance and relevance. Your Chief Justice made it coincide with stone laying ceremony of new High Court arbitration building. Apt and appropriate it is to have such a conference on this topic on such a relevant occasion. It was a creative idea of the Chief Justice. Yesterday, there was a documentary shown, and I saw the outer elevation of the proposed building. I noticed three pillars. Not pillars, but pillars like projection. The three different sizes were there in the pillars. And the biggest pillar was of institutional arbitration. You again see it and find it out. As we invariably belong to this High Court, I also feel elated to see the new arbitration building coming up. And that will take the institutional arbitration as envisioned by all forward. When this juncture marks the closure of the conference, looking at the stalwarts and experts who participated and they guided the discussion, there is no gainsaying that you must have very extensively and in-depth manner deliberated the topics and subtopics. There are a variety of topics on which the sessions were held. I just recapitulate for myself. Concept and framework of the institutional arbitration, institutional versus ad hoc arbitration, crossroad movement, ethical and efficient process of dispute resolution, how to achieve it, how to make a good arbitral award, essential parameters, evolving hybrid models of dispute resolution, MEDARB, etc. While expressing my views on the subject, I connect the thread which the Honorable Chief Justice of India, Mr. Surya, yesterday highlighted. He emphasized three aspects for arbitration: transparency, integrity, and justice. The regime of arbitration started with a bang, but in a quick mode, its credibility started crumbling. Why? It started losing integrity, number one. Number two, it often searched for transparency. It distanced itself, the process, from real justice for which it was intended to, as alternative redressal system. The present day arbitration, I always say, is by and large, not always, is a corporate arbitration conducted in corporate way for corporates and carries with it the corporate cost. So these are the ills of the present day arbitration, which is called ad hoc arbitration. And so this new concept appears to be getting evolved. Further, a common man finds himself at a bay from involving himself in the arbitration remedy. The process is marred by delay, escalating cost, as I said, credibility, both of arbitrator as an individual, as well as an instrumentality in conducting the process. They are plummeting in standards. The most preferred provision in the Arbitration Act for the arbitrators, you know which is that? Section 29A. They go on seeking the extension of time to complete the arbitral award. So that is most beloved section for arbitrators. Arbitral awards are supposed to be the win-win resolution of disputes between the parties. They are expected to be cogent in their details. They are supposed to be the pieces of documents of substantive and real justice, satisfactory justice. But the awards today are rinsed and soaked, SOKD, with cut and paste philosophy and suffer from thoroughly non-judicial syndrome. The arbiters are judges, but the awards doesn't reflect that application of mind. of a judge of a judicial kind. Arbitration, as we know, is founded on partly party autonomy. Traditionally, many disputes in India were resolved through arbitration. In such proceedings, the parties themselves used to determine the procedures, often adopting rules such as those framed by the United Nations Commission on International Trade Law. While this model preserves flexibility, it also places significant responsibility on the parties and arbitrators to manage timelines, fees, and procedural discipline. In contrast, the institutional arbitration is conducted under the supervision of a recognized arbitral institution, such as International Chamber of Commerce, Singapore International Arbitration Center, London Court of International Arbitration, or in India, Mumbai Center of International Arbitration, and one more, the would-be Gujarat High Court Arbitration Center. These institutions do not adjudicate disputes, but it is said that they facilitate and administer the process. They provide structures, rules, appoint arbitrators wherever necessary, supervise the timelines, regulate the fees, and in some cases scrutinize the draft awards before they are published. It is true that comparatively the institutional arbitration surpasses in terms of acceptability and its utility the ad hoc arbitration. First, it provides procedural certainty, reducing delays that often plague the ad hoc proceedings. Second, institutional appointments mechanisms reduce court intervention. In ad hoc arbitration, failure to appoint arbitrator frequently results in application before the courts, further delaying the process. Third, institutions often provide administrative support through case managers and monitoring systems. Fourth, some institutions conduct scrutiny of awards also. And quality control mechanism is available over the entire process in this way. Fifth, the institutional arbitration enhances credibility in cross-border transactions. The MEDARB concept, in my view, could be more furthered and facilitated through institutional arbitration, because one can have a panel of mediators to be attached to the institutional center who may participate in the arbitration process also wherever necessary. So the institutional arbitration can be a blend of arbitration, mediation, and also conciliation by evolving such mechanism consciously for such institutions. At the same time, let us not forget the utility of ad hoc arbitration. It should not lose its relevance. It may be suitable for smaller domestic disputes where parties enjoy equal bargaining power and wish to minimize the cost. The flexibility of ad hoc proceedings can be advantageous for the parties who are cooperative and hail from the common strata of the society. You know that arbitration has been developed and intended to be developed as alternative dispute resolution system. The idea is to deliver justice. Jurisprudentially and ideally, as well as really, the meaning of justice has a necessary intake of quickness in delivery, credibility, confidence of the stakeholders, efficiency, effectiveness, and all the more important, harboring of sense of contentment and satisfaction amongst the rival sides. Arbitration has to be supplemental to the justice delivery as an alternative mode of redressal. The way the ad hoc arbitration developed or has developed, it has acquired the discredit of becoming antithetic to justice rather than to become synthetic to justice. Finally, the concept of justice, I would say, is itself an institutionalized concept. Justice delivery can be more effectively delivered or dispensed through institution rather a individual judge or individual handler. Because the individual arbitrator is always prone to human follies like bias, dishonesty, subjectivity. These are the ills which are taken care of when we opt for institutional arbitration. Amar said in the beginning in the discussion, आग तो जलती रहनी चाहिए कहीं भी ક્યાંય પણ હોય પણ આગ જલતી રહેની છે. હું કહીશ કે આગ તો ad hoc arbitration જલાવી જ દીધી છે. આગ જ આગ છે બધી જગ્યાએ. Now we want to lighten a jyot. So, let the jyot is enlightened and let the High Court Arbitration Center as an institution take the credit of ushering the institutional arbitration to its real virtues. But then I have a caveat. Every activity, moment, or crusade succeeds through the character of the persons who are handling it. So there are many young lawyers are here, young arbitrators are here. So the ball lies in their court to prepare themselves simultaneously with the erection of the new building. So this is all for today. It was a wonderful gathering. I have never seen in this High Court such a large gathering in the valedictory session. And this valedictory, let me say, is a misnomer. We are not marking end. Look at the subject. At crossroads and way forwards. So we are starting from this point of time. Thank you.
We are deeply grateful for the illuminating valedictory address, Your Lordship. May I now request Honorable Mrs. Justice Vaibhavi Nanavati, Judge, Gujarat High Court, to felicitate Honorable Mr. Justice N.V. Anjaria, Judge, Supreme Court of India.
With this, we formally conclude the two-day conference on the theme Institutional Arbitration at a Crossroad, Challenges and the Way Forward. Over the past 2 days, we have engaged in thoughtful deliberations, meaningful dialogue, and enriching exchanges on issues that lie at the heart of contemporary arbitration practice. We place on record a sincere gratitude to the Honorable the Chief Justice of Gujarat, Mrs. Sunita Agarwal, and the judges of the Gujarat High Court for their constant encouragement and gracious support. We also extend a heartfelt thank you to the administrative staff and to every individual whose dedicated efforts made this conference possible. Their meticulous planning and commitment ensured its smooth and successful conduct. Finally, we thank all the distinguished speakers and participants who enriched the sessions with their wisdom and expertise. We take this opportunity to thank everyone present here, including retired High Court judges, the speakers, Mr. Birendra Saraf, Justice Wazifdar, and all the students and lovely audience we have here. Your presence and engagement have truly elevated this conference. We look forward to welcoming you again for many such meaningful interactions in the future. Thank you.
We would also especially like to thank Justice Sonia Gokani, former Chief Justice, Gujarat High Court, and Shri Kamal Trivedi, Advocate General of the State, for remaining present with us. Thank you once again and have a good evening.